Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Thank you and good morning. I have a couple of housekeeping matters I'm going to address in a moment, but first I'm going to introduce the panel to you. To my right is Justice Shin. To my left is Justice Robert Toone. My name is Vuono. We have 6 cases on for today. We're going to take a short break after the 3rd case. So we're going to be hearing 3 criminal cases and take a short break after the 3rd case. The 4th and 5th cases that are on today, there's an emergency motion to decouple them, so to speak. They were going to be consolidated for oral argument, and originally we had ordered that the parties would have 20 minutes each. I don't know if the parties are in the room right now, but we'll let them know later when they do arrive that we're going to allow that motion, and that's in cases number 2022-0922 and 2023-0437. The appellant will have 15 minutes to make her argument in both cases, and the appellee will respond in both cases. So we'll address that again right after the break. But if they're here in the courtroom now, they can be prepared for that. All right, so I don't think I have to tell the 2 of you that you have 15 minutes to make your argument and that we have no rebuttal in the appeals court and that we've read everything that you've provided to us, and so you can get to your most important points as soon as you can. Commonwealth versus Luis Torres, 2023-0812.
Good morning, and may it please the court. Nick Madison for Luis Torres. In Mr. Torres' jury trial, the Commonwealth repeatedly referenced a previous incestuous sexual relationship between Mr. Torres and his half-sister in a trial where on charges of an incestuous sexual assault of Mr. Torres' daughter, LT. Because trial counsel failed to object to this evidence, that constituted ineffective assistance of counsel. For this and the other reasons referenced in my brief, a new trial is required. Focusing first on the relationship between Mr. Torres and LT's mother, there's 3 things that I'd like to focus the court on. The first is that this evidence wasn't merely referenced, it was highlighted for the jury. The references to Mr. Torres' relationship with his half-sister.
And when you say highlighted, you mean because it was mentioned in the closing argument? Or argued in the closing argument, so to speak?
Most importantly, during the opening statement, the Commonwealth said, quote, "It is important for you to know that Mr. Torres and LT's mother are half-siblings that share a father." So the Commonwealth started in its presentation to the jury saying that this is important information for you to know. It was then elicited through 2 witnesses and referenced, as Your Honor points out, again in closing argument. So
what do we do about the judge's finding, who was also the trial judge, right? And he found that the evidence did not feature prominently in the trial. So how do we, what do we do with that?
Well, Your Honor, the judge did make a finding to that effect. I would say that the transcript speaks for itself as to the Commonwealth referencing that it was important information for the jury to know. The other aspect of this is, given the strong taboo that involved in incest, an incestuous relationship doesn't have to be referenced very many times for the jury to pick up on it.
You would agree that the trial judge has a much better vantage point than we do in assessing whether this evidence featured prominently during the course of the trial, right?
Certainly, the motion judge presided at trial. I would argue that in the context of evidence of incest, which has such a strong social taboo, the fact that it was referenced not just once but multiple times, and the risk here, and this is a point that I think where the motion judge erred. The motion judge was only considering whether in his decision on the motion for new trial was only considering whether the jury was overwhelmed by emotion. He said that he had instructed the jury not to act in that way, and that a similar instruction specifically as to this evidence would have made a difference. What the judge overlooked was the likelihood of propensity reasoning involving this evidence. And once the jury, even if the judge is correct that it wasn't emphasized during the trial, the fact that the jury heard about a prior incestuous relationship more than once, and that kind of evidence lends itself towards propensity reasoning insofar as the jury was likely to think, well, if Mr. Torres had a consensual relationship with his 16-year-old half-sister, he may be the sort of person who's inclined towards, or at least not adverse towards, a relationship with a sexual conduct with a close family member, as was charged in this case.
Was a child, though.
With a child. That's correct.
A significant difference.
It is, but the incestuous nature of both the relationship lends itself to propensity reasoning.
But there wasn't any kind of propensity type argument from the prosecutor about this, right? There wasn't. They didn't argue or try to make that connection, and they never used the word incest. No one ever used the word incest, right?
No.
So it just is the fact that this was mentioned. You're speculating the jury could have drawn this connection and sort of made the kind of propensity-based reasoning, right? But that's all we have to go on, just the fact that this was mentioned.
Your Honor's correct. There wasn't an explicit propensity argument, and that the word incest wasn't mentioned. I know the Commonwealth has referenced this in its argument. I believe that it was made clear to the jury in the multiple references that Mr. Torres had a sexual relationship with his half-sister that produced LT. The fact that that wasn't labeled as incest in front of the jury, I think, notwithstanding that, the jury would have understood what was being talked about there, which was an incestuous relationship between half-siblings. And given the strong social taboo against incest, that would have been salient in the jury's mind. It would have, during deliberations.
And the trial counsel said in his affidavit, well, I didn't object because I thought it was reasonable background evidence, right? And that's essentially what the Commonwealth argues now. Like, they needed to know this relationship to understand all the cast of characters. They didn't harp on it, but they sort of thought it was important for the jury to understand who each person was. Is that not a valid reason to not object?
So what trial counsel articulated was half of the analysis that needed to be done for this sort of bad act evidence. The first question is, does it have some probative value? And then how is that balanced against the risk of unfair prejudice? What trial counsel articulated, and the Commonwealth has articulated the first half of that analysis. They didn't apply, trial counsel didn't consider the second half of the analysis, which is the risk of unfair prejudice, which I've tried to focus the court on the propensity risk, the risk of propensity reasoning in this case. That would be my response. And the other issue I'd like to highlight is, notwithstanding the risk of, the high risk of propensity reasoning in this case, the jury received no limiting instruction as to this evidence. They were never instructed that propensity reasoning, notwithstanding, as the Supreme Judicial Court has noted in Creighton, that propensity reasoning has a certain logical force to it in amongst jurors, amongst lay community, and notwithstanding that strong inference, particularly where there's a general similarity between the prior bad acts and the charged conduct here, which would be the incestuous nature of both relationships, would be the common denominator there. There's a high risk of propensity reasoning. The jury was never instructed that propensity reasoning was impermissible. It was never instructed on the any permissible basis for that information. And so the jury was going into the jury room with evidence that lent itself a high risk of propensity reasoning without any instruction or clarification on the court that that was not permissible. And that is one of the many reasons that there was a reasonable likelihood that the failure to object to this affected the jury's verdict in this case.
So they did acquit on one of the charges. So that's at least some indication that they were able to look at the evidence critically, right?
So the Supreme Judicial Court in Dwyer addresses that. Your Honor is correct. The jury did acquit on the charge of rape. It did convict on indecent assault and battery. In Dwyer, the Supreme Judicial Court notes that the strength of that inference, that the jury was not, the defendant was not prejudiced on the basis of an error, is a contextual determination that depends both on the error and the trial. So while that might have more force if the error were evidence that might unduly cause the jury to act on emotion, a split verdict, that inference may be stronger in that context. In the context of propensity reasoning, that's not as strong as an inference, particularly in the case here where there's a substantial difference in the strength of the case as between rape and indecent assault and battery. The evidence as to penetration in support of the rape charge was quite inconsistent as far as LT's allegations. The evidence was more consistent as to the indecent assault and battery. So it's entirely consistent with the acquittal on rape and the guilty verdict on the indecent assault and battery, where the jury could have found, well, the evidence was so inconsistent as to penetration, I can't credit that. But given the prior incestuous conduct, Mr. Torres seems like the sort of person who is, as I said before, either inclined towards or not adverse to sexual conduct with family members. So I think it's more likely that that there was some sort of sexual assault. I still have reasonable doubts over penetration. And so.
How is that different than what the hypothetical you started out with? What if the claim is that there was a risk that the jury were carried away by emotion? It's the same, right?
So the distinction that I'm trying to draw out here is when the jury is overcome by emotion, the issue is that they're not exercising their kind of critical facilities in weighing the evidence. They're overwhelmed by emotion. Perhaps they want to punish the defendant. A split verdict shows that they weren't doing that. Where the issue is the risk of propensity reasoning, the gaps in the evidence may matter because the propensity reasoning may overcome a smaller gap than a larger one. And so given that the evidence was rather inconsistent on penetration, as I indicated before, less inconsistent as to that some sexual assault occurred, then the jury could use the propensity reasoning, say, I think it's likely that some sexual assault occurred because of, in part, because of his willingness to engage in other sexual relationships.
Are you essentially saying it's more likely in this case that there was a compromise verdict rather than a rational verdict? Is that your point?
No, I'm not saying that it was a compromise verdict. To Justice Shin's point, what I'm trying to point out is with propensity reasoning, you can still be engaging your critical faculties in weighing the evidence, but the propensity reasoning can get you over a smaller hurdle than a bigger hurdle.
Okay.
I'm not sure if that answers your question. Whereas with emotional reasoning,
it should be across the board, is what you're saying.
That's more likely to be the case, and the inference coming from a acquittal on one count and a conviction on another count is the inference is stronger that they weren't so carried away.
And the inconsistent testimony that you're referring to with respect to the element of penetration is just the comment that was made to the first complaint witness, right, to the mother. not at trial, because at trial, the victim was pretty straightforward as to what had occurred. Is that what you're referring to?
Yes, so
Okay.
there was prior inconsistent statements that were elicited at trial, as well as evidence from the doctors who examined LT the same day as the when it was the alleged sexual assault was reported, and that there wasn't any injury consistent with a sexual assault at that time, although the doctors did note that that doesn't occur in every case.
Right. Okay.
Turning briefly to the issue of burden shifting, I would just note that the rhetorical question of what is their theory of why and who made it up is the exact sort of question that courts have noted, particularly in Johnson, the explicit pointing to the defendant and saying, why haven't they come forward with evidence to challenge the Commonwealth's case? This is the exact sort of rhetorical question that courts have found to be burden shifting in the past. And
Johnson ultimately found no prejudice based on what seems to be a similar set of standard instructions that were given here, so.
yes, it did find no prejudice. There are, I think, two salient distinctions as to the prejudice analysis. The first is that the statement here went to the heart of the case. As the judge noted in his decision on the motion, LT's credibility was the issue at trial. This burden shifting argument was focused directly at LT's credibility. And the second is the standard instructions didn't cure the inference that the Commonwealth was asking the jury to draw, which was to draw an adverse inference against the defendant on the basis of his failure to come up with evidence. There was no direct instruction telling the jury that they couldn't do that.
Okay. I'm going to see if the panel has any further questions for you, because your time is up.
Could I just ask one more question on
Absolutely.
this point? It does seem like the statement in question was asking what the logic was underlying the defendant's argument that the victim was lying. In a sense, the defense says, you know, they're saying the defense says the victim is lying, but there's no internal logic to that argument. So that's why they say, what's your theory? That seems conceptually different from the situation in Johnson, where the prosecutor suggested that the defense attorney had a duty to counter the Commonwealth's evidence. Do you think is that a legitimate distinction between those two cases?
I would disagree with Your Honor. I would respectfully, I would say that the earlier rhetorical questions were that point where the Commonwealth was drawing out what motive does she have to lie? That is permissible insofar as it's commenting on the defense that's been presented. Once the Commonwealth points specifically to the defendant and says, and makes the argument that the defendant hasn't come forward with evidence to counter our case, that's when you get across the Johnson line. That was the problem in Johnson. That's the distinguishing factor, I think, between the cases that find burden shifting or no burden shifting.
Thank you.
Any questions? Thank you very much.
Thank you.
Good morning. May it please the Court. Assistant District Attorney Cynthia Payne on behalf of the Commonwealth. The Commonwealth is asking this Court to affirm the judgment of conviction in the order denying the defendant's motion for new trial. Here, the motion judge, who was the trial judge, properly denied the defendant's motion for new trial. Trial counsel was not ineffective for failing to exclude evidence of the half-sibling relationship between the defendant and the victim's mom. Here, as was noted, the trial judge, who was the motion judge, found that this evidence was probative. He found that the prejudicial effect was minimal. He found that the evidence was relevant background information. Here we had two individuals who are of legal age. They did not live together. They did not grow up as traditional siblings. There was no evidence at all that the relationship was anything but consensual.
And if that's the case, why even bring it up?
Your Honor,
Because none of what you've just said right now was actually presented to the jury about their background situation and that kind of detail.
I would point out everyone in this case had the same last name. Defendant had the same last name as his dad, who was instrumental in driving the victim to and from Maria's house. As the trial judge found, this was relevant background information. The trial judge also found this was not this was not emphasized, and trial counsel conceded that the Commonwealth had not focused, notwithstanding the few words, it's important to know, that was used by the prosecutor
But isn't your opponent correct that the judge's analysis was incomplete? And he says relevant background information. Then he doesn't actually address the claim, which is had a risk of being used as propensity, and there had to be a weighing analysis against unfair prejudice. He never did that.
Well, I would note that the motion judge did find afterwards that there was no the prejudicial effect was minimal. So I would suggest there was.
He analyzed it as whether there was a risk the jury would be swayed by emotion, which really wasn't the claim. The decision is, I don't know what the right word is. I'm going to go with dismissive. See, it has a dismissive tone to it to me. It didn't analyze the claim as a prior bad acts claim. It didn't analyze the second claim either about the character evidence. So what do we do with that?
I would say that, well, I'm going to start with that trial counsel's, and if I'm not answering your question, please let me know.
We will.
His not objecting was a strategic decision. In trial counsel's affidavit, he specifically said that he considered about filing a motion to eliminate, but decided not to. He determined that again, that it was background information that would come out.
He didn't go further either. That's the point, right? I mean, even if there was some marginal relevance to this background information, why isn't that outweighed by the risk that the jury would use this unfairly?
I would say even if this very minimal, this was not repeated, this was a half-stated, not more than 4 times. This is a half-sibling relationship.
How long was this trial?
2 days?
Yeah, so 4 times is not, nothing.
I would respectfully suggest that this was not repeated. This was not emphasized. The trial judge found this was not emphasized. Trial counsel conceded that it was not. And I would suggest that right there, that suggests that the tone and the manner, the fact that this was not emphasized. But most important, the fact that the defendant was acquitted of the most serious charge. I would suggest right there that counsel is not, that the defendant did not prove the 2 prongs of Safarian, did not prove that counsel's behavior fell below that of an ordinary fallible attorney, and certainly did not prove prejudice. The instruction, I would suggest, was more than just bias. You may not be influenced by bias, may not be swayed by any personal dislikes, can't be influenced by personal feelings. Again, there's a big difference, I would suggest to this court, between using the word incestuous relationship and this was a half-siblings who did not grow up together. Individuals, there's no evidence of anything that was not consensual. In regard to the character, Your Honor, what you have articulated as character evidence, the Commonwealth would respectfully disagree.
Well, no, I'm not saying it is character evidence. I'm saying the judge didn't say one way or another anything about this claim, right?
Well, I would suggest that here, in trial counsel's affidavit, he said he originally believed that this line of questioning went to opportunity, but he only decided that the questioning had gone too far after he was provided, I would suggest, by appellate counsel with the transcript. So the fact that there was no objection, again, I would suggest goes to the manner and in Toone that this was not prejudicial.
Well, you're correct, of course, that we rely on what the trial judge observes. The case law says that, and that we also look to what trial counsel actually says. But in this case, to your point, we also have the transcript, and so where we cannot determine if there was emphasis or tone of voice, we can see that the jury was told that this was important to know early on in the case. The witnesses talked about it, and then it was addressed in the closing argument, which I find the most perplexing, because I don't see how it was relevant to any of the issues with respect to the actual sufficiency of the evidence, or why the case should be, why the defendant should be convicted. So we can see that, right? I mean, we can read those different times that was brought up.
Of course, I would refer the court to Commonwealth v. Hampton, which was mentioned in the Commonwealth's brief. Where there was a split verdict, the underlying case, one of the charges was an indecent A and B on a child, or individual under 14. The defendant in his statement had indicated he had watched adult pornography, and the issue was whether or not that should have been admitted. The court found that that was error, but that it was not prejudicial, much because there was a split verdict, just as in this case. The most serious charge, the rape of a child, defendant was acquitted of that case, of that charge. I would suggest also in regards to the jury instructions, closings are not evidence. The judge repeated that both in his preliminary instructions, immediately before closing instructions, and during final instructions. In regards to the single rhetorical question, which my brother challenges, the Commonwealth would suggest that this was a rebutting defendant's argument that the victim had lied. This was these 11 words within a 4,000-word closing argument, nestled among 14 other rhetorical questions, in the middle of the prosecutor's closing argument, not at the end, as my brother had suggested in his brief. I would suggest that that this argument was proper. I would suggest that the one rhetorical question, what is the theory of why and who made it up, was not improper. And even if
surely prosecutors know that asking what is their theory is problematic, right? Now, it may be in context, it's that the impact was minimal, but that's, I assume in prosecutor school, people are taught, don't ask what is their theory, right? Would you agree with that?
I would agree with that, but I would suggest that this is similar to the case of Montez and Brigoli, where the court found both statements were proper. In Montez, the prosecutor's statement that the trial counsel never addressed certain evidence was not a comment on the defendant's failure to present evidence and didn't shift the burden of proof. And Brigoli, prosecutor said, defendant presented no evidence, no explanation for certain evidence. And again, the court found that was okay, that was not error. Even if error, I would suggest, as in Johnson, where the court found that it did not rise to the level of prejudicial error. I would bring one additional matter to the.
I just ask you, is one of those two cases involve the prosecutor here, because she does mention the fact that she has been appealed twice on a similar vein?
I
didn't check.
Whether Montez or Brigoli, whether
Yeah,
those.
I'm assuming that those are not some of the cases that she was involved in, because she does say that
I
she's
don't
been
believe- I don't
taken up
believe-
twice and I've prevailed both times.
I don't believe, Your Honor, that either of those cases.
I don't think so. Do you know what cases she's referring to by chance?
I do
I
not.
don't
but
want to put you on the spot, but I just was
But
wondering.
I can certainly
That's okay. No, that's okay.
I can send a letter to the
No, if you
court.
knew, it's all right.
I would just bring to the court's attention in regards to my brother's issue of number 4, Dr. Boo's testimony of the claim being it was an endorsement of the victim's credibility. I would just point out, which I had not pointed out in my brief, that the judge instructed the jury both based the typical expert witness instruction that you can believe all, some, or none. But more importantly, he provided an official response instruction, and that's on volume 4, page 59. You've heard testimony about an official response to the complainant's allegation that included police officers, doctors, and forensic investigators. The fact that resources were brought to bear on an investigation is not evidence of a belief in the truth of that allegation. You are to draw no inference one way or the other about the perceived belief of any of those official actors. So I would just bring that to the court's attention.
Can you give me the site for that, please?
Sure. Volume 4, page 59.
I mean, I just have a general question about why is this one of the criteria for why do you open the door to this testimony that there's been enough suggestion that an act has taken place? It seems, to the extent it means anything, obviously there has to be some reason why they're administering this test, but it's hard for me to understand why that is a criteria that needs to be introduced to the jury.
I would suggest it was
Because
clarified.
it does seem to have a potentially vouching type effect.
It was clarified. I would suggest his words were not the best words that he could have used, but it was clarified. Volume 3, page 96. The exams are performed for medical concerns that are brought to me, to him, that are directed by subjective information. So I would suggest that there has to be information, histories in the first place as to why this person has come, so that enough suggestion that somebody's saying that there has been an assault. Here, victim and her mom indicated that the defendant had placed his balls on her butt and back. So I think the issue was there was no discussion with, nobody provided a history of penetration. So I think that's, let me back up a moment. I would say that the criteria was not about the victim in the first place, that this was the overall criteria. But as to when...
Which gets to the point why it's always a problem to have the recipient witness also testify as an expert.
That's correct, Your Honor. Although the courts have said, certainly in Alvarez, as long as the questioning is careful.
I know, I'm familiar with the case law, but I interrupted you right in the middle of your comment. I'm sorry.
No, just that this was not, this was the criteria, this was not directed at the victim. This was just when doctors know how to perform, that there has to be some kind of history as to what brought the individual to the hospital in the first place.
Just seems kind of self-evident and unnecessary for someone to testify about. That would be my observation.
There's a disagreement over whether this issue was preserved. It does seem like the hearing on the motion in limine concerned the potential for implicit vouching. You don't think that was enough to put the judge reasonably on notice of what the basis for the objection was?
I wanted to bring to the court's attention that this was at this point in time, when he objected, it was a generic objection, but
Right.
The Commonwealth's point further on was, no matter what the standard of review was, there was no error.
Okay.
Unless the court has further questions, the Commonwealth would
I'll
rest.
check right now. No?
Thank you.
Thank you very much. Thank you both for your arguments. They were very helpful. All right, the next case before us is case number 2023-0673, Commonwealth versus April Marie Restrepo.
Excuse me.
You understand? You have your water right there? Okay.
Yeah.
All right, good. All right.
Good morning, Your Honors.
Morning.
Penelope Cathawala for the appellant, April Restrepo. This case, excuse me, involves actually just two arguments that the appellant puts forward. The first being whether or not the trial judge erred in allowing the body camera statements obtained by Officer Rivera on the night in question were improperly allowed in over the objection of the trial counsel. And the other, of course, is whether or not the issue of self-defense with respect to, excuse me, the denial of the defendant's motions for required finding. So let me proceed first with the first one, Your Honors. With respect to as Your Honors are aware, as you said, you have seen this, the purported victim was not present at the trial nor did testify. So, of course, the almost major issue in the case is the purported admissions and statements by the defendant on the Officer Rivera's body-worn camera were actually the certainly relevant admissions or admissions of party opponent that got the conviction, we would say, of Ms. Restrepo. I would first...
Can I ask you a housekeeping question first? So we received Exhibit...
Excuse me, Judge, I'm
That's
sorry.
okay. We received Exhibit A and B, if I have that correct, right?
Those are the clips.
Or was it 1 and 2? I'm sorry. Okay. I don't want to. And can you tell us, I know that you weren't trial counsel, but that you would be familiar with this. Were they shown in their entirety to the...
They were not shown in their entirety. The Commonwealth's, I don't recall the gentleman's name, I think Mr. Jones, actually had redacted them. So they were, both of them were clips of certain portions of the arrival of Officer Rivera.
I don't think I was clear with my question. Of the 2 clips that we have in our record right now, okay, were those entire clips shown to the jury?
The 2 clips that you have, yes, that's what were shown.
So including the part where the officers are talking on the radio and identify the partner as the victim and the defendant as the suspect, that was shown to the jury? Is that your understanding?
I believe that was as well. I was not trial counsel, but I believe those were the actual exhibits at the trial, 1 and 2.
But because the confusion, I think, is that the prosecutor in the motion in limine to introduce these says that he intended to not include those portions because they would be A, inadmissible hearsay, and B, unfairly prejudicial. But we can't tell from what we have whether or not that was actually, that part of the first tape was actually presented to the jury. There's evidence in the record that suggests that it was, and of course that's all we have to go on. So I think it's a pretty important thing to ascertain.
Okay. Well, the clips, excuse me, Judge, the clips I have are what I understand was submitted to the court.
Thank
you. Excuse me. So as I said, the purported victim did not appear, so there was no testimony from the victim, only, as I said, the body-worn camera clips that Your Honors have seen, and then Mr. Restrepo's own testimony at the trial. I would just suggest, and I mean, of course, the standard review is abuse of discretion was a prejudicial error. I'm suggesting, with respect to the fact situation here that Your Honors know about, you read or saw that Ms. Restrepo, as she testified, was trying to put laundry away. A controversy arose. The purported victim said, "Don't go in that room." Ms. Restrepo, whose home it was, wanted to go put her laundry away. Somehow a verbal argument ensued. That increased while they were in the bedroom, where the purported knife, which you'll hear about in the second issue, was on the table or in the desk.
In the nightstand, I think, right?
A nightstand, yes. And the argument escalated where it became physical. Ms. Restrepo testified at the trial that she was knocked down. She had a head injury, a bump on her head.
I wonder if we could focus a little bit more on the admissibility of the statements that are present on that body cam, that were introduced at trial. So that was objected to, as I understand it, on the basis of the reasons that you're now talking about, that your client had been injured, she had been hit on the head, that she was, et cetera. And so we have to determine whether or not those statements should have been introduced, or whether there was any prejudice introduced in those statements. She also spoke to the police on the 911 call.
Yes.
Okay, and do you think that that is important in terms of your argument to, which is that she was distraught and not able to actually give a statement at the time? Because we have not been provided with the 911 call.
And I understand it was heard at trial, wasn't in the testimony, and I was not able to obtain
Yeah, it was,
that call.
I think, introduced as Exhibit C. So have you reviewed that?
I have not reviewed that.
Okay.
I did not obtain that from trial counsel. There were other things I obtained that were inadmissible, but that was not given.
All right, and then I'll ask you, while I have you here, what about the medical records that were introduced, of the medical records of the alleged victim or the partner? We don't have those actually either.
I believe the medical records that they were referring to related to the purported victim.
Yes.
And again, I did not receive those.
Okay.
And they were, I think, highly redacted, other than she refused treatment, which she said somewhere in the transcript she didn't want treatment, even though EMS came. So going back to Ms. Restrepo, I would simply say, and you'll hear this in my second, she attempted to, was her house, this young lady, Miss Leon De Leon, was a visitor staying there for some time, but I think you read she didn't pay for anything. She just helped with the laundry. It was also the home of Mr. Restrepo's father. The incident that occurred in the bedroom. As you heard from the testimony of Ms. Restrepo, she was hit on the head. She had a bang on the head. I believe that also is in one of the clips, I think Officer Rivera's clip, that she had hurt her head and banged her head, and that she'd been hit a number of times. I suggest to you that she ultimately left that area, left her children, ran. In one place, the officer says, yes, I know she ran. I noticed that Mr. Restrepo, at her testimony, said she walked barefoot to the home of her children's father. It was unclear why that gentleman, the father, had her former boyfriend, had called 911. I know from the testimony they were outside, and he handed her the phone, and she made some statements to the 911 people. And then, of course, Officer Rivera, and I believe it was Ho, arrived. And you saw those parts of the clip. I'm just suggesting to the court, due to her head injury, the fact that she was distraught, that she had run and/or walked barefoot, without keys, without her cell phone, to the father of her children's home, that she was really in no frame of mind or in any cognitive way able to make any kind of statement. She was questioned, not Mirandized, but was questioned by the...
She wasn't in custody when she was being questioned by the officers at the house, right? She wasn't in custody until she was arrested.
I do not believe she was in custody.
So it's not,
Right.
I know that trial counsel raised a voluntariness issue, but that only really kicks in if she's in custody. So the point as to the head injury more goes to sort of just the unfair prejudice of introducing this information and the unreliability, and is that your argument?
Yes, and she had made inquiry and asked for medical treatment. different than the purported victim. And she was questioned prior to the medics or the paramedics coming. That whole communication in the clips were questioned and answered prior to her receiving any treatment from EMS. With respect to the, and I certainly would suggest again where with the second motion, the second issue regarding whether or not the trial judge improperly denied the several motions for required finding and/or directed verdict, and I would just suggest that the issue that at least was put forward by defense counsel was that the whole incident was one of self-defense, and that the Commonwealth had to prove that one of the elements, at least, that Ms. Restrepo acted properly when faced with an aggressor. She was in her home, and she ultimately did leave her home.
Well, can I ask you
Yes.
about what I think is the heart of the Commonwealth's argument, which is that the defendant's own statements, you can infer from them, perhaps, that she was the aggressor. And then they argue that self-defense is not available when someone starts the fight. What do you say to that?
Well, I think as I reviewed the trial transcript, that it depends on when you ascertain when this incident occurred. Because it appears if you go to the start of how they started this argument, Ms. Restrepo was simply trying to take laundry and put it away.
No, that's her testimony, right?
That's
okay,
hers.
but the Commonwealth is relying on the statements in the video. Essentially, the statement, I got physical with her and she got physical back. But does that, in your view, is that enough to establish that she was the initial aggressor?
Well, not if you look at the totality of how this incident occurred, because I'm suggesting that it was the purported victim who started this argument in the bedroom and said, don't go in there, your father's sleeping, the kids are sleeping, stay out of there. Ms. Restrepo said, I want to put the laundry away, it's going to get wrinkled. That started, what I'm suggesting is actually the argument and the fight. It started out verbally and then escalated to physical. So I'm suggesting to you from the police officer's body cam, he said, well, who got physical? Well, if that goes in, she had said, rightly so, well, I did, but that was, I think, out of the threats of what was occurring with the initial argument. So I'm saying you could look at it in two ways.
So you're saying it's not enough, that statement is not enough to prove that she was the first aggressor?
Yes.
Okay.
That she was the aggressor, the first aggressor.
Initial aggressor,
Correct.
okay.
Yes. With that.
What about her saying, oh, the officer asked, any weapons involved? And she said, yes. Who had them? Me, a knife, right? Is that seems damaging to your self-defense position as well? That seems unhelpful to your self-defense argument as well.
Well, other than, and I'm sure you learned how the height of Miss De Leon was like 6 inches taller than her, and they had already had a scuffle. She had had her head banged. She had bruises. There were photographs. They were not admitted. I think you saw that in the motion hearing part of this case. So I'm saying, I guess I'm saying I felt the Commonwealth has to prove she did not act in self-defense, and they did not meet their burden.
Thank you.
I see no additional questions from the panel, and unless you have anything to add in 20 seconds, you can rest on your brief.
Thank you.
Okay, thank you.
Good
Good morning.
Good morning. May it please the court, Carolyn Renero on behalf of the Commonwealth, asking that this court affirm the defendant's conviction.
Okay, let me just interrupt you for a second and say welcome. We understand you're a student practitioner.
Yes.
Okay. Get ready. We have a lot of questions for you. So I'm glad that you have somebody here with you, just in case. So and you probably won't forget this argument. So let's just start right now with the video clips. Is it true, or is it, can we reasonably infer that the entire 2 video clips that have been provided to us were presented to the jury? And if that's the case, why wasn't one of them redacted in the way the prosecutor said that they would be redacted?
Your Honor, if the portion of the video clip that Your Honors were previously describing of the officer speaking over the radio was provided to Your Honors in our record appendix, then that would have been an error on the Commonwealth's part. As the record appendix states on page 10 of the motion for admission, the clip was shown to the jury from the beginning through 5 minutes and 52 seconds, and then it was clipped and then began again as Exhibit 2 from 9 minutes and 24 seconds to 12:30, which is when the officers tell Ms. Restrepo that she had to go with them. So I apologize if Your Honor saw that version of the clip. The jury did not.
Okay, that's
Well, I'm going to get the chronology down here. So they play the first tape for 5 minutes, and then they play it for 40 seconds, correct? And then stops to ask questions to Officer Rivera to confirm the details of the video. Then they play the video again that goes for about 5 minutes. And then they continue to playing the video, and it's not clear how long it plays after that. But the chatter among the officers occurs at about minute 6. So if they play 5 minutes of the video, stop, and then play more of the video, how can we tell from this record that they didn't go into the part of the officers describing the defendant as a suspect?
Your Honor, my understanding is that that portion of the video was not introduced at trial. However, had it been introduced at trial, I still don't believe it would be unfairly prejudicial because it simply shows the police officers responding to a domestic violence altercation in their investigatory capacity.
But the prosecutor at trial said it would be inadmissible hearsay and unfairly prejudicial. So you're disagreeing with his statement at the motion in limine proceeding?
Well, I think it would be preferable that the clip was cut, and my understanding is that it was at that point.
Is there actually an exhibit of what the jury heard, or are we just going on the clips that we provided and some assurance that they got cut off? I mean, is there actual, normally in trial, what's presented to the jury is called an exhibit, and we see the entirety of it and what's not included. Is there anything like that here, or
Yes,
is
so
we just have to rely on sort of guesswork about when a longer clip was stopped?
We don't have to rely on guesswork because the exhibits were divided into 2, and so the first exhibit, Exhibit 1, was until the point that I mentioned, 5 minutes and 52 seconds, and then Exhibit 2 was the latter half, which is the portion of the video that does include Ms. Restrepo's statements, which is from the 9-minute, 24-second mark to the 12-minute, 30-second mark up before she was arrested. So they were divided, and so Exhibit 1 is referring to the first half before the radio communications of the officers, and Exhibit 2 is primarily the defendant's statements that are at issue.
Right, but we just, after they replay for the third time clip 1, we don't know how long that goes. And if it goes beyond the 5:52 mark, then it goes into the portion that the prosecutor himself said would be inadmissible hearsay and unfairly prejudicial. And so that's my question. We don't really have any record of when this clip stopped. When it was presented to the jury.
Right. I'm happy to clarify and ensure that the court has the correct versions of the clip. I just can't. My understanding was that it was cropped at the proper place.
Your understanding is that the jury did not see that portion. Is that what it is? All
Yes,
right.
that's correct.
And then the issue is that how well can that be established, given that the record is silent on that part? All right.
Okay, I'm a little bit confused now. So we have two clips. One is 9 minutes, a little over 9 minutes, and the second one is a little over 3 minutes. Your position is that the 3-minute clip, 3.5-minute clip was played in its entirety, and the 9-minute clip was stopped at 5:52, and then nothing after 5:52 was played to the jury?
That's my understanding, Your Honor, yes.
With the caveat that that's your understanding, but as Justice Toone is pointing out, it's not actually clear on the record that they stopped at that point, right?
Correct.
Okay. So I guess is your next argument that if we're unclear and we're not sure, I think you started to mention earlier that despite what the prosecutor, how the prosecutor described this evidence, that you think it would not necessarily cause undue prejudice.
Yes, Your Honor.
Okay.
So I'll begin with the probative value of Ms. Restrepo's statements. And the probative value here cannot be overstated. The defendant's statements are highly probative because they are her own admissions of exactly the fact that's the central issue in this case, which is the fact that she was the first aggressor, that she grabbed a knife and then struck the victim with the knife. And it supports exactly what the Commonwealth's theory of the case was. And in addition, the statements were made shortly after the altercation happened. So the temporal proximity of the statements to the altercation also adds to the probative value.
Did she say she struck the defendant with a knife? I didn't recall that. She said I got physical and she got physical back. And then she also mentioned the knife was there. I don't recall her saying that I struck the defendant with a knife, or struck the victim with a knife.
Well, Your Honor, on the body-worn camera footage, she says, as Your Honor mentioned earlier, that she had the knife. But then to the Commonwealth's theory of the case that she struck the victim with the knife, the Commonwealth introduced other evidence in regard to that, including Officer Kaplan's observation of the victim's injury and, yes, the observation of the victim's injury.
Okay, but that's not what she said during the body cam tape, right?
No, but the body cam tape supports the theory that she was the first aggressor and escalated the fight. And the officers asked the defendant what happened that night. As you mentioned, she said that she got physical with the victim and the victim got physical back. The officers then confirmed, you're saying you got physical with her and she got physical back, and the defendant responded, yes.
And so it's the Commonwealth's burden to disprove self-defense, right?
Yes, Your Honor.
And is that the only proof?
No, Your Honor. The Commonwealth disproved the victim's self-defense claims in two different ways. In the Commonwealth's case in chief, the body-worn camera footage disproves the self-defense by showing that the defendant was the first aggressor using her statements. But in addition to that, the defendant's own testimony later on also refutes the self-defense claim.
Explain that to me. I'm not seeing that.
So the defendant must avail herself of all means to avoid physical combat, and if the defendant had the opportunity to retreat and did not do so, that would also defeat her self-defense claim. So in this case, there were 4 instances during her testimony where she refutes, she shows that she had the opportunity to retreat and did not do so. So that would be on page 108 through 109 of the trial transcript, and also 115. On direct examination, the defense attorney asked the defendant what happened, and she said that she fell on the ground and while arguing with the victim in the bedroom. And the defendant responded, I left, I went out into the hallway, and then I went into the living room. So that shows an opportunity to retreat. That's on page 108.
But didn't the slicing of the thumb happen in the bedroom?
Your Honor, it's unclear from the testimony exactly when it happened. The defense attorney on multiple occasions asked when she got the knife. Was it before the victim punched her, or it was after the victim punched her? And it just is entirely unclear from the defendant's testimony.
Okay.
But she also said, the defense attorney also asked, when you were still in the bedroom, could you just leave the bedroom and leave Ms. Leon de Leon inside the bedroom? And to that, the defendant responded, yeah, I left her. I was on the floor, I got up, and I walked away from her to get away from her. That's on page 109 of the trial transcript. So that also suggests that she had the opportunity to retreat, and given that the standard for the required finding of not guilty, the court should look at the evidence
Well,
in the light.
she did retreat. She went to the living room.
Right.
I thought the timeline was there was an altercation in the bedroom. The victim was on top of her, punching her, and she grabs the pocket knife from the nightstand while still in the bedroom, and then she says she accidentally cut the victim's thumb, and then she retreats and goes into the living room, and the victim follows her. Is that not the accurate timeline?
Your Honor, it's unclear that at what point the defendant grabbed the knife. I don't think that she, at any...
I mean, I didn't see anywhere in the testimony where that would support a timeline where she retreated into the living room and then returned to the bedroom, which is, I think, what you say in your brief. I didn't see that in the testimony anywhere.
No, Your Honor, that's not what we suggest in the brief, but what we do suggest is that the defendant says that while she was in the bedroom, she did have the opportunity to get up and leave, and she did not do so. But even if there was no opportunity to retreat at that moment, the self-defense claim would still be defeated by the fact that she was the first aggressor and stated in the body cam footage that she got physical with the victim first. And given
Yeah, but
that,
we're trying to find out if there's anything besides that statement that kind of supports that sort of disproves the self-defense point. I mean, she retreated to the living room. She eventually left her house and walked, barefoot 6 blocks away, or how many, right? So there is this narrative of she trying to get away from the altercation. So what else besides that statement in the body cam footage really establishes proves that she did not engage in self-defense?
Your Honor, I don't believe that there's, other than the defendant refuting the claim in her direct examination, or suggesting that she did have the opportunity to retreat in her direct examination, and her own statements saying that she was the first aggressor and confirming that twice to Officer Rivera. There's not additional information because the victim did not testify in this case, but given that we're looking at this in the light most favorable to the Commonwealth and drawing all reasonable inferences in the Commonwealth's favor, that's enough to defeat the...
I want to be precise about what's on the body cam. You said she admitted she got physical first. I did not hear anywhere on the body cam where she said the word first. Is that accurate?
She says, I got physical, and she got physical
Right,
back.
so she never says first, right?
Right.
Okay. So, I mean, maybe you can infer that means first, but is that enough proof beyond a reasonable doubt standing alone?
Your Honor, it is sufficient, and in addition to that, the Commonwealth also introduced the medical records and the testimony from the police officers. So we're not relying on the admissions alone. Certainly the Commonwealth introduced supporting evidence and circumstantial evidence, but these admissions are, as I mentioned, highly probative. They go to exactly what the issue at trial is, and notably the defendant had the opportunity to get on the stand. And in relation to the 403 issue, she does contradict her own statements on the body cam footage, but that's a question of weight and credibility for the jury. And in this case, the jury determined that the footage was more credible.
I have a follow-up question, but I don't want to interrupt you. So the medical records that you're referring to, those are the medical records of the partner of the victim, and all they indicate, I'm assuming, since we don't have them, is that there was an injury to the thumb. Is that right?
I believe so, Your Honor, but I haven't reviewed the medical records.
Okay, so that leads me to my second question, which is, it seems to me that they would be something that we might need. And But more importantly, and I know your time is short, I'd like to refer back to the 9/11 phone call that was played for the jury twice, I believe, I can't remember, on more than one occasion. And if the defendant's argument is that at the time that these statements were made to the police, that are depicted on the body cam, that the defendant was distraught and suffering from a potential concussion, and therefore could not make a statement in any reasonable way, and that therefore not that the jury should not weigh them in a certain way, but that the judge should have not let them not introduce them in the first place. Don't we need to look at that 911 call? I mean, she herself describes her voice on the call when it's being played for her as groggy.
Your Honor, the defense doesn't challenge the 911 call. They didn't challenge the admissibility of the 911 call.
But what they're challenging is that she was not in a state of mind to be able to give a statement to the police at the time that she did. And it seems to me from that it's pretty clear that her statement is the linchpin of the Commonwealth's case.
Sure. I think the trial judge was well positioned to view the defendant's cognitive ability, or whether she was mentally had a mental impediment or physical impediment at that moment, to make a statement. And the trial judge was able to review the body cam footage in its entirety. And
so are
make that
we. So are we in the
determination.
same position as a trial judge with respect to that, to determine whether or not she could give a statement? Because we had the exact same evidence that he had.
I'm sorry, Your Honor, can you?
We had the same evidence as the trial judge in this case. I'm not sure if it was who tried the case. We had the same evidence, and so we reviewed the body cam. So are you saying that we are in the same position as the trial judge to determine whether or not the defendant was in a position to be able to give a coherent statement or anything along those lines?
Well, to the extent that Your Honors would come to a different conclusion, that's not enough in this case. The standard is that the trial judge's decision wasn't in the realm of reasonable alternatives, and I think certainly the Commonwealth has met its burden in showing that it's reasonable that the prejudicial effect of the defendant's distraught state in this case did not outweigh the probative value.
All right, I took you over your time. I'm going to see if the panel has.
I just have one more question about the clips, and maybe if there's any more information that you can provide us about the video clips. I just note in your brief at note 7 on page 17, it refers to trial exhibit 1, and then it says in parentheses clip 4.1, and then clip 2.1. At the very least, I think those are the wrong clips for each exhibit. 2.1 should come first. I may be wrong about that, but that seems to correspond to what I saw in the clips. So if we could clarify that, it would be very helpful to me. As well as if there's any other evidence of an actual exhibit that corresponds to what the jury was actually provided.
Your Honor, can you repeat the page that you mentioned?
Yes, of your brief, page 7, note 1, I believe, there's a footnote that discusses the trial exhibits 1 and 2, and it seems to me like they were referring to the wrong clips.
Thank you, Your Honor. We'll clarify that.
Okay. Great. Thank you very much. We're going to hear one more case this morning before we take our, not this morning, we're going to hear one more case before we take our break, excuse me. The next case is 2023-0734, Commonwealth versus, I'm not going to use the name because, of course, this case is partially impounded. So we're going to talk about the juvenile, and we're going to talk about.
It's a YO, so his name.
So, all right. Well, I see partially impounded with asterisks, and I just will check my record. But you're counsel, so you're counsel. So I'm gonna trust what you have to say about it.
It's partially impounded because of the nature of the case.
Well, I assumed that, but okay.
Good morning. May it please the court. Eva Jellison on behalf of Dylan Welch, and I'd like to acknowledge that several members of Dylan's family are in the courtroom, that Dylan is watching on YouTube, and that other family members are watching on YouTube. I'd like to address the first two issues in my brief, the juror issue and the cross-examination issue, and if the court has other questions, of course, I will take those questions. Turning to the juror issue, I'd like to apologize. It is juror 65. I reversed the number in my reply brief if that caused any confusion. Disabled jurors have a constitutional, statutory, and federal statutory right to participate in jury service. And the defendant's right to a fair jury trial and the protection of disabled people against discrimination work in tandem. That's from the Haywood case from the SJC. Here, the only person who was improperly excluded from the jury was a disabled person. And I'd like to talk a little bit about why that was an improper exclusion first. The totality of what the judge did in this case evinces that she either explicitly, and I wouldn't say that, but implicitly discriminated against this autistic juror. Her first comments, before even interacting with the juror, but based on a report from the court officer and from through the juror's mother. The judge announced that there would be an autistic juror appearing. She called him a boy. She said that he probably wouldn't be fair and impartial, but that they would go through the process and that his mother wanted him to go through the process.
And that she would also withhold judgment, right? Isn't she
She
also
stated
said
that, yes.
Yeah.
She stated that. When we got to the actual jury, when the juror came before the judge, and if you listen to the recording, she talked to him in a really markedly different way than she spoke to other jurors. They went through the same colloquy that she went through with other jurors. He answered entirely appropriately. He had not raised his hands to any questions. And it was after that portion of the colloquy that she brings the attorneys to the side, and she says, okay, well, I'd like to excuse him for cause. He's an autistic person who was brought here by his mother. You know, is there any problem with that? Both attorneys do have a problem with that. Defense counsel wants to ask questions. The Commonwealth seems to agree. The judge is perplexed by this. The judge was perplexed why the mother didn't accompany the juror, but she's perplexed by this. She says very pointedly to the prosecutor, you don't agree that because he's autistic and he came here with his mother today and she just wanted him to experience jury service, that he shouldn't be excused? And the prosecutor said no, perhaps she thought that he could experience jury service, not just jury selection.
Right.
And
the judge didn't really disagree with that and then called and said, by all means, let's call him back for additional questioning.
Correct. And in that additional questioning, I think it's even more clear that he is fit to serve. He answers the questions appropriately. He's able to talk about the fact that he graduated from high school, that he's a good listener, that he had an IEP, that he got a little extra time on assignments, and that was because he's autistic. And it was after that that the judge said, all right, I intend to excuse this juror. I very well might do that over any objection. We're going to excuse this juror. And that entire process, rather than going through the process that the SJC suggests should be gone through in Haywood, where you inquire whether a disabled juror can access the evidence, be fit,
Let
and if they need
me
any
just ask you,
reasonable-
let's just say we would agree with you.
I'm sorry.
Let's just say we agree with you 100%.
Okay.
All right, okay.
Perhaps that's why I'm not getting any
Oh, no,
questions.
I'm just saying, let's just say, hypothetically, all right?
Hypothetically.
Hypothetically. What do we do with the fact that after the judge says, brings the juror back for more questions and says, and indicates what her intentions would be, but asks what they have to say, that there's no objection to excusing this juror for cause? Because
Yeah,
that,
so-
to me, seems to be a critical issue.
Yes, I think it is a critical issue. I have essentially two answers to it, maybe three. The first one is that in ALVS, and I know that Your Honor concurred and disagreed with this point, but the majority in ALVS seem to say that where there's this improper exclusion of these jurors, that right is so fundamental that there didn't even need to be an objection to the 9 jurors that the judge improperly excluded. Now, there was an objection to 2 of them, and I understand that. But from ALVS, I draw that this is so fundamental, and it's so clear on the record. You know, there wasn't as if the judge needed to be alerted to this issue. It was very clear on the record. So to me, ALVS stands for the
You
proposition.
mean in ALVS it was clear on the record?
Yes, it
Are you
was
talking
clear on
about
the
that
record.
case or this case?
Oh, I'm talking about this case.
Okay.
I feel like the judge's conduct was very clear on the record, both in ALVS and in this case.
But Alves, there were 2 objections to two of
There
the
were 2
jurors.
objections.
Do you have any case that says no objection is still a structural error that
So
requires.
what I take from Alves, and you may disagree, but what I take from Alves is that the judge said that there were objections to the 2, but that all 11 were the problem, that there was a problem with striking all 11 jurors, and there were no objections to the 9. So I take from that you don't need an objection to this, where it is clear on the record, where it is a judicial error, and where it operates to deprive the defendant of a fair cross-section of the petit jury. Now, if that's not acceptable to the court, I had an alternative argument in my reply brief that there really, at this point, the objection was futile. Counsel tried to object, the judge, and this is really looking at the totality. The judge announces before we even see this juror that she's inclined to excuse him. I understand that she says she's going to bring him in. After just a brief colloquy, she's inclined to excuse him. When defense counsel objects to that, there's more colloquy, but there isn't an examination of this juror. The judge, when she comes back at the end, she's not responding to that colloquy. She's not talking about individual characteristics of the juror. She has not conducted a colloquy that would understand if this juror needed any reasonable accommodations. It's not a search. I'm
So
sorry.
she says it's on a close case.
She does.
Right? And then she invites any objections. I'm going to give you the chance, any challenges. So it's very difficult for me to say, based on that objection would have been futile when she's inviting counsel to express any objection.
And I understand that, and I take your point. The totality of how this went, to me, at that point, I feel like defense counsel would have found this objection to be futile. She even says, I might do this over objection. She has been pretty persistent. She's been pretty pointed about wanting to excuse this juror and not agreeing with the attorneys that even further inquiry was necessary. I know she allowed it, but I think that does make out futility. And if a judge continues to kind of press in one direction, I think that can make out futility. And I cited a couple cases in my brief, which I don't have the name of on the top of my head, that I thought kind of went to that inquiry. But I will say as one last point, if the court is inclined to agree with me that this was an abuse of discretion in excluding the juror, but that there is a problem with preservation, I think that you could make out prejudice in this case. And the reason that I say that is because this juror was uniquely similarly situated to both Dylan and, as a pseudonym, Anna. He was a teenager, a public school student, and someone who had accessed special education services. Both of the people involved in this case were similarly situated, had trouble academically, were teenagers. There was a lot of text message evidence in this case. I think that a teenager, a 19-year-old, and I think at this point Dylan was 18, would have been uniquely able to assess this case. And then another thing I would point to the DLC brief at pages 29 to 30, where they talk about the fact that autistic people often are able to use deliberative reasoning and logical reasoning better than neurotypical people. And I think in this case, with the type of evidence in this case, that would have been actually particularly important. So to the extent that I need to prove prejudice, I wanted to present that prejudice argument to the court. If there are no further questions on the juror issue, I can move on to the cross-examination issue. Thank you. So to start out, the judge cut off cross-examination of Anna, again a pseudonym, and she was the most important witness in this case, hands down. If the jury did not believe her, I don't think that they would have been able to come to a conclusion of guilty on rape. And another thing about her testimony is that it was not fully believed. The assault with intent to rape charge, the jury acquitted of, and that was also based on Anna's testimony. So we're looking at a witness that was not fully believed by the jury and was very, very important in the case. And to that point, any further erosion of her testimony or support of Dylan's theory of the case really would have mattered. This was a close case.
Well, do you disagree that of the 3 or 4 areas that defense counsel indicated and wanted to continue to explore at the end of the day? Because I think that the court adjourned it a little bit after 4 o'clock that day.
I'm sorry, could you speak up?
Excuse me. I think that the trial adjourned a little bit after 4 o'clock that day. In terms of what happened at the end of that day, the end of the first day that she testified, would you agree that those areas that were cited then had already been covered during the course of the cross-examination?
I would disagree with that.
Okay.
and I'll go ahead and explain. And would you like me to focus just on the ones that were raised in that first
Well, there were
day?
3, so maybe you can pick the one that's you think is the most important.
Well, the most important is certainly the one that counsel raised immediately. So counsel was brought up, the cross-examination concluded pretty much, or the judge raised an issue with it, right after counsel had played a video which showed, it's 2 videos. One showed Dylan and Anna walking west near a regional transit center, and then walking east near the regional transit center. And counsel was able to ask only one question about that, is that you in the videos? Yes. He was unable to explore anything, he was unable to explore anything else and unable to ask any other questions about that video. And if he had been able to ask other questions about that video, for example, Anna testified that she walked behind Dylan during the entire time that they walked in the first portion of walking. The video contradicted that. Counsel wanted to ask her about that contradiction between her testimony and the video.
And what would that have, how would that have changed things? The jury had the video.
They had the video, but I mean, you have to be able to explore with the witness, I think, why there was an inconsistency. Was this just memory? Was this, was she sticking with it? Was this a lie? I think they needed to be able to explore.
Yes, I'm trying to understand how that could have been helpful to the defendant to give her the opportunity to explain why her earlier testimony was apparently inconsistent with the actual video that the jury could see.
I see your point. I think it would have at least highlighted the inconsistency more than counsel was able to do otherwise. And there are other portions of the video as well. That's just one. I think the other thing is that there was never, at least with Anna, there was never a reasonably clear explanation of where the sexual contact occurred or what direction they were traveling. And I understand that the video shows that, and there hadn't been very much inquiry on this point. Counsel tried to ask if they had gone left twice, once without any reference to anything and once with reference to a photograph. I think that this could have helped him to have Anna testify specifically as to when the sexual contact occurred. You can infer where it occurred based on some of her other testimony and the video put together, but to clarify that would have been particularly important.
And why is that?
And I say that because of this point, and I think that this was the strongest piece of evidence in Dylan's case for his case. And it's that Anna testified that when the sexual contact occurred, that she began bleeding immediately. To the extent that you can infer, but I think to the extent that you could pinpoint that the sexual contact occurred before 3:18 p.m., which is when the BRTA video of them walking east has the timestamp, you can also conclude that it took 3 hours for her to get to the hospital from that point. And that's at the impounded supplemental record appendix 6. I know that's not cited anywhere, so that's at page 6. So it takes 3 hours for her to get to the hospital where she's bleeding heavily and bleeding out. And I think you could infer from that the injury in fact did not occur during the sexual contact. Now, that is not the only inference, but there is an inference that amount of time, with the amount of blood loss she was experiencing when she got to the hospital and the severity of her injury, that injury simply didn't occur during the sexual contact. So to the extent that counsel could have explored with Anna, and he didn't even get the opportunity to explore with Anna given the video, the location of where this happened, that we could have gotten to a point where that was even clearer, and he could have argued with more force that Dylan did not cause this injury. And I think that would have been incredibly important to his case, both on the point of consent.
Well, there's no dispute that the contact would have happened no later than when she arrived at the store, right? Which is 4:22. So it's undisputed there are approximately 2 hours that elapsed between that point, which is the latest point at which it could have occurred, and when she went to the hospital. How would the 1 hour have materially changed anything?
I mean, so there's zero medical testimony in this case about what could have caused an injury like that, how long it would have taken to bleed. I think that some of that might have been helpful. But I think adding an hour to that, it just makes it seem more incredible to me that level of bleeding could have occurred for that amount of time and that she would have still been able to, get into the car with her mom, get home, talk to the police officer. So I think you can make that inference. I'm not, you think you can make that inference.
And she did say that she walked for what seemed like a long time, right?
She did.
Okay.
She did, but the question is, did this sexual contact cause her injury. Now, I agree that she walked for a long time. I think that's clear from the BRTA video and the location of the Sunoco station.
No, I thought she said she walked for a long time after they parted ways.
She did.
Until she, okay.
That's right.
Okay.
Absolutely. My time is up. I can rest on my brief. Unless there are other questions, I'd be happy to answer them.
I'm sure that you will. I'm going to check with the panel to see if we have any additional questions. And no, thank you. But the brief is very thorough.
Thank you so
You
much.
can rely on your brief. Thank you.
Good morning, Your Honor. Stephen Greenbaum from the Commonwealth. And
Good morning.
if I could ask the people, I'm having a little trouble hearing, probably age-wise, but if the...
Oh, we'll be very careful and we'll use our microphones.
can use
just
your
like we ask
microphones.
everybody else to do it for us, so no problem. Is that loud enough for you?
Thank you. Yes.
Okay,
thank
good.
you. I want to emphasize in this case that the standard of judgment on the juror issue is abuse of discretion, which means a clear error of judgment. And I don't believe and the defendant has the burden of showing that. In this case, the defendant hasn't shown a clear error of judgment. What the defendant has shown, in addition with the amicus brief, which makes many good points, is that this judge perhaps didn't have the level of understanding and expertise in autism, if you want to call it a mental disability, to have gone through an inquiry that perhaps might have led this judge or another judge with a better background to say, well, maybe this person is competent to serve. If you look at the information provided in the defendant's brief and the amicus brief, it's clear that an issue is raised. Autism is a neurological and developmental disorder. I guess everybody's assuming it qualifies as a mental disability, and for purposes of this argument, I'll agree with that. Well, if you've got a mental disability, a juror with a mental disability, then that's a different issue than a juror with a physical disability, like in Haywood with a blind juror or whatever. We're talking about a juror's capacity to involved in decision-making. And to the extent that this information about the mother telling the court officer that I want him to have the experience, could have initially raised a flag, and we don't know what else the court officer told her, but could certainly have initially raised a flag as to whether this particular juror was so dependent upon his mother or his parents for decision-making that perhaps he would not be competent to be a fair and impartial juror, just to start with. And then beginning with that, then we have, I know...
Would you agree if one was to read the record and the questions that were posed to Juror 65 and how the juror responded, that there did not seem to be any indication of a lack of ability to perform the functions of a juror?
From the straight words in the record, yes.
Yeah.
But the key here, the judge said presentation. I know there was no detail about what she meant by presentation. I don't know what she meant by presentation. The amicus brief gives us some notions of what certain autistic people may present in terms of lack of eye contact or other things that may have been going on there. I'm not sure, but...
I think that was one of the interesting points in the amicus brief, that presentation is such a vague term that necessarily invites the observer's views as to what they're seeing, and what the focus should have been is on competence. Can this juror actually perform the duties that he would have as a juror? And there didn't seem to be much in the way of analysis about that. There was the question about him being on IEP, but a lot of people are on IEPs this year, and the fact that he got extra time, that can't be disqualifying to serve as a juror. So there really wasn't much of a factual basis for the judge to conclude this juror wasn't able to serve, at least from the record that we see.
Yeah, yes, and I'm not sure in this situation if a judge finds excuses a juror necessarily there's any requirement to put a detailed factual basis, particularly when there's no objection. And I disagree with my sister's reading of the record. There was no objection ever to dismissal for cause. In fact, before the initial voir dire questions asked by the judge, when the judge asked, I'm inclined to dismiss this juror, I keep on saying, juror for cause, defense counsel said no. He didn't say, I want to ask. He said, no, I have no objection. And then the prosecutor said, well, I'd like to ask some questions. She didn't say she objected to cause. She wanted to ask some questions. We don't know why, but she went ahead and asked. She wanted to ask questions. Defense counsel went ahead and asked questions. When he was done asking him a few questions, the prosecutor had no more questions. And then the judge came back, do you object to removing him for cause? And they said no, which means either this court is going to have to infer either they agreed with the judge that there was something about his presentation that made them believe he wouldn't, and the other information they have that he wouldn't be a competent, fair, and partial juror in a week-long rape trial. Or the other possibility is either or both of them certainly intended to exercise a peremptory challenge anyway, and the judge saved them the trouble. As counsel said, this is a very similarly situated person to both the defendant and the victim. And either the prosecutor or defense counsel said, I don't want a 19-year-old boy on this jury. I don't know who he's going to side with here, perhaps on his own immature experience. So that in terms of if it was error, it's certainly been waived by their absence of objection.
What do you say about the request that we actually listen to the recording of the colloquy?
I've listened to the recording. The problem you have with the recording is you don't know how different that judge's tone was with any of the other jurors. Yes, she uses this very, I'm not sure how that.
We haven't, you can hold back on your interpretation of what you heard on the recording, because I think that actually is part of the problem with taking a look at the recording. My question is a more generic one. If you have any opinion as to whether or not a panel like this one should be listening to the recording to look for things like demeanor, et cetera.
It's interesting that we created, opened the door to incredible questions about jury selection. I suppose if a defendant believes that there's something in this particular colloquy with tone that indicates something, we didn't object to that in this case, and if perhaps tone revealed something that the words on the page didn't reveal, I don't think that should be forbidden, but it hasn't occurred to me whether or not that should be something the court should get into.
Well, the motion asked for the recordings to be transferred for two reasons. One is to listen to the tone during the juror selection, but also to listen to the cross-examination of the victim relevant to the second issue. Do you have a position on that, the second issue?
I don't see how that will make a difference. Listen to the transcript. There's nothing in the transcript that indicates inaudible or anything. I think everything that transpired during the cross-examination is in the transcript. So I don't know how the audio of that. I believe the defendant's trying to feel like the judge was the judge pressuring the defendant to end the cross-examination. I think that's the point, perhaps, of asking you to listen to the video, and you can read it in the transcript. The judge is saying, look, it's been over 4 hours with this witness. It's 4 o'clock. How much more do you have? You're going on to location again. They've talked about location ad nauseum, and both direct and cross in this case, and all they got from the victim was, I don't know. It all looked the same to me. I don't know. There was no reason to believe anything else was going to be, your answer was going to be anything other than, I don't know, I don't recall, I don't remember, I never knew it. So in that case, I don't think the audio helps because.
Well, just let me point out, if there is something inaudible, the rule is that the parties go before the trial judge and then certify to us what was actually said. So that's a different question for which we actually have an answer. We have a procedure.
I did not look into whether or not this is permissible.
I want to be clear about that. But thank you for your response, and we understand what the position is on that from the brief.
Do you have a response to your opponent's claim that it should be structural error?
Yes. Well, in order to find structural error, you would first have to find that the exclusion was improper. Structural error doesn't come about because you don't get a jury.
Let's assume there was an error.
And the error would then be
the error was not preserved. What's your response to the argument it should be considered structural error?
I think if that's structural, I think you still have to show, and I think it's the jury closure cases we have where there was closed courtroom cases where there was no objection and that was structural error. You still are required, where there's no objection, to show some prejudice, some form of prejudice, where you, in some cases, of structural error. And I would say in this case, where the issue is not that a juror might have been improperly excused who's in a protected group that might have had an effect one way or another. In Alva's, it's a cross-racial.
So the structural error, the cases that say it's it's structural error, whatever the error was, they all involve preserved errors? Is there any context in which an unpreserved error is considered to be structural error?
You know, I can't say I know for sure. All I have in mind are those closed courtroom cases where they say that an impropriety in jury selection or other things, which is typically structural error, is waived if there's no, if it isn't preserved. I can address that in a follow-up letter, but I didn't address it in my brief. But there may be cases where, I think there are cases where it could be waived. I would sort of agree with counsel that even if it hadn't, I don't know what would have happened in Alvis if there had been no objections at all, whether the court still would have reversed it despite the absence of objections, but I did not address that.
Okay.
Any other questions on that? And I just would point out that the defendant's got to show, even if it were wrong, the defendant's got to show prejudice. And here, the fact that there wasn't this one autistic juror, you're guaranteed the right to have a jury drawn from a fair cross-section, but not have the ultimate jury seated that has a fair cross-section. And then sometimes it happens, and I cited to those cases. And again, I think there was a difference. There is a difference here in terms of exploring. It's clear the judge didn't just decide, I'm not going to put this person on because of the disability. I says, I want to inquire. My understanding is this disability may affect his ability to be a fair and impartial juror, and made that inquiry. Maybe people would disagree with her opinion, her final decision, but I don't think that's a clear error of judgment.
What about, just not to focus on this issue, but if the judge did find there was some kind of impact, the DLC says, well, in that situation, you have to treat it like you would under the ADA and sort of consider whether there are accommodations that would allow the juror to serve, notwithstanding the impact of the disability. Do you disagree with that analysis, that you have to go through a kind of accommodations inquiry if you do find that there's
I've read the amicus brief. This is part of the amicus brief suggestions appendix or whatever, and it makes a lot of good points, but it starts off by recognizing the time and constraints of jury selection, and what the amicus suggests is that someone with a disability, regardless of whether it's autism or otherwise, have an opportunity to file some in advance, raise that issue so that when the judge comes in, they can make accommodations. That's not part of wasn't part of the process at this point in this trial. It's not part of our process now, and perhaps it should be. The only part of the process would be if you want to be excused because of a mental disability, which this defendant, juror, apparently did not do.
But the whole notion of the ADA is that people with disabilities should be included in the
It could impact, but let's assume for the sake of argument that the judge, and I'm not going to assume, but let's assume the judge was correct in finding that some factor in this juror's autism, neurological developmental disorder, rendered him not competent to serve the proper function of a jury. I don't know how you can accommodate that to render his neurological processes in a way that would make him competent in that situation. But again, I don't know. I'm not an expert on autism. I don't know what could be done. It's possible. But in this particular case, it didn't happen. There was no reason why there was no reason to expect that it would happen. Amicus makes a good
we have no idea what the judge's view on why this juror wasn't competent to serve at all. That's the problem.
We don't have specifics,
correct.
You don't have
any sort of, this juror
and the
can't
defendant
do X.
didn't file a motion for new trial to elaborate on that. So we don't have that. We don't have any information from either counsel on either side that might have been elicited in a motion for new trial. So we're left with the record, and the burden's on the defendant to show the abuse of discretion.
Mm-hmm.
I don't think any more questions on the juror. As to the other issues, I would rely on my brief, I think, with the bottom line that this case, well, let me just see.
Could I ask you one question, actually, on the second issue, the limitation on cross?
Yes.
You say that only one of the claims was preserved, and the
Yes,
others
if
were
you read
not? But at the end of the first day of her testimony, the Commonwealth's intent was to bring her back the next day for further testimony. And then the next morning, the Commonwealth says, well, we changed our mind. Can you hear me?
No, I can hear you, but I disagree. The
Oh,
Commonwealth
okay.
did not say, the Commonwealth asked, the judge asked the Commonwealth whether, the prosecutor, whether she was going to bring the witness back, the victim back for redirect. The prosecutor said, can I have 5 minutes to think about that? The
And the
judge said,
judge said
no,
no,
5
right.
minutes, you'll let us know tomorrow.
Right, so at
But
that
she didn't
point-
indicate she was going to bring her
Okay,
back.
but at that point, nobody knew whether the Commonwealth was going to bring the victim back
That's
to
correct.
testify. And then the next morning, there's this written objection that was filed. Victim's not there to testify,
Yes.
and the judge says your rights are preserved. So why isn't that enough for it to be a preserved error?
Well, in order to preserve the error, the objection has to specify, even in cross-examination, well, what did I not get to cover in cross-examination that I would have wanted to?
And so I thought.
Oh, I see what you mean.
Yeah, and then the judge says afterwards, your rights are preserved. So I just want to.
Well, again, we're getting into say that the judge had made it clear, look, we're done with cross. Your cross is over at this point. Do you have any more questions? The defense counsel took time to confer with the defendant and his father, came back, just had this one question about social media, asked the question, was done, and that judge made it clear at that point in the trial, if there's anything happens next, it's redirect. Now, it's possible at that moment, if the defense counsel had gotten him and said, oh, wait a minute, I just thought of this, the judge could still do the same thing, denied. And I'd still think that that didn't preserve the fact that when counsel initially stated, she said, what's your offer of proof for further cross? His offer of proof was, I want to ask about location. I'm sorry, I wasn't doing what I said I should do. His offer of proof, when the court made it clear, I'm ending the cross-examination unless you have more pertinent stuff to go, he said, I want to ask more about location. That's all the defense counsel told her. Now, he might have changed. You can always change your mind. You can always sit down and say, oh, geez, I didn't ask this. You can come back the next day, oh, geez, I wish I would X, Y, Z. But that doesn't mean you preserve the objection. It just means you're hoping to get another chance, and the judge can grant you that. But there's no abuse of discretion there. And what I would say, in all the other claims, even if there was error or abuse of discretion, impropriety, the evidence in this case was overwhelming. And the defense is someone else caused this injury. Well, this is the possibility of any error, if it existed, affecting the verdict is virtually null.
Okay.
Questions?
I think you've answered the questions from the panel, so you can rest on your brief as well. Thank you both very much.
Thank you.
Both of your arguments were very helpful today. Thank you. All right, the panel is going to take this morning recess now for about 15 minutes, and we'll come back and hear the remaining 3 cases on our list.
Court is in session. Please be seated.
Okay, it's still morning, so good morning. This is a case in which we had originally indicated that each side would have 20 minutes to present their argument, and we received an emergency motion from you to ask to have your full 15 minutes for each appeal that's before us, and we've allowed that motion. So it's going to be a little bit of up and down. You will present your point of view with respect to the first appeal. And excuse me, that's going to be on our list, the 2022-0922 appeal. And then you'll respond, but stay exactly where you are, because then I'll call the second case, and then we can argue that case. I do think that some of the issues may run into each other, and I will want you to know that if you want to give us some background now, you don't have to repeat it again the second time around, all right? So we'll be a little bit fluid with respect to that.
Okay.
All right, so now I'm going to officially call the case 2022-0922, JAYNE Silva versus Sherry Stanley and others.
Good morning, Your Honors, and may it please the Court. There are two possible ways of interpreting what this argument is about. The procedural facts demonstrate indisputably that I timely filed my notice of appeal from the Housing Court summary judgment, that an affordable use and occupancy pending appeal was put on me. I did not owe the use and occupancy if I didn't go forward with the appeal. I timely appealed that under the indigent court cost law, and only under the indigent court cost law, the court has recognized that was the basis on which I appealed. As this court knows, the argument has been significantly persuasive that the SJC is now considering that question, at least for now. I may
Let me
have-
ask you a question, if I
Sure.
may. So I think the case that you're talking about is Frechette versus Brown?
Correct.
Okay, which was argued in the Supreme Judicial Court about 3 weeks ago? Okay. Do you have a view as to whether or not we should wait to decide, issue a decision in this case until that case is released?
Correct, yes,
Do you think that we should?
yes.
All right, so we'll still, of course, listen to your brother, to the opposing counsel here. Just so you know, generally what that means is that we don't issue an opinion, we wait for that opinion to come down, and then upon occasion, we ask for additional briefing and a very short time schedule to determine whether or not what the result should be after the case comes down. All right? And with that, knowing that, you still think that that's what you're requesting us to do?
Yes, Your Honor.
Okay.
Okay, sorry, where did I leave off? Because indigent court cost law provides for a waiver, substitution, or government payment, and only one of those three options once you have been found legally indigent. It is to be liberally interpreted because it is a constitutional equal protection and due process statutory expressions of our constitutional guarantees to access to the court and equal treatment in the court. I knew that the housing court denies all these a lot, but I also knew that there was a way to get government payment, at least for a while, to cover the cost and make it more attractive to the court to do what the Constitution requires as expressed in the indigent court cost law.
Let me ask you, is your view that you were entitled to receive payment for the appeal bond as well as for the use and occupancy payments?
I got use and occupancy payments from the government. I did get help, and the plaintiff tried to refuse them, but as the law, the court has to accept court government payment. So I did that for my appeal to go forward.
Okay, those, and when you're talking about your appeal to go forward, you're talking about the same case, right? The case in case number 922?
Correct.
All right.
I know it's so confusing. I'm pro se, so it's hard. I'm learning.
Well, you're doing fine. Just keep going.
Okay. I got money. The plaintiff refused to do their piece of the paperwork. The judge who sat on the ordered them to take that use and occupancy money that was only owed because I had an appeal going forward. Then apparently having taken the money from the government, given it to the private party, plaintiff attempted to dismiss the very appeal that was the condition for taking the government money. I refiled for a clarification there because since the money had been ordered to be taken and was only owed if I were allowed to go forward with the appeal, it didn't seem that the court could then essentially defraud the state government of the money and dismiss the appeal. So I put that in front of the housing court again. Then Chief Justice Horan heard that and understood that I was still working on the appeal from the judgment and ordered that, yes, I could go forward with the only notice of appeal that I had at that point, which was from the judgment. She ordered that the record had to be assembled and sent up. It is pretty clear that she took the initially conflicted decision of the judge who had been presiding over the case and cleaned it up, so that the court was not in a position of having defrauded the state government of money. That is the only notice of appeal that existed at the time of that decision that exists. It is that case that is in front of you. Since then, everybody else, including the judge that she overrode, has tried to say that the internally conflicted decision meant that the appeal had been dismissed. But the judge who sat right afterwards agreed that it wasn't, ordered the record sent up, and it was sent up. So it seems very clear that the procedural facts that what it was in front of you in the appeal for the summary judgment, that is very clear that the other side did not defend against any of my arguments as to why the summary judgment was wrong. The summary judgment was dependent upon a chain of title that the third party is under our law, charged with both the evidence of the registry of deeds and the court case with the bank. They are charged with knowing that, but even if they weren't, the chain of title that they were claiming is clearly void because the title transferred to me out of a probate judge order. That ordered me to protect me from a murderous ex-husband, to completely separate our marital estate so that my children and I would not be stalked or killed by him. So I got the title to the property as part of a gender protective law. My rights since then have been ignored, as if I hadn't gotten the title of property. Clearly is an equal protection right here down to the line. Article 1 of our Constitutional Bill of Rights says, your unalienable right to the property shall not be denied or abridged because of sex. So whatever housing court decision was made trying to uphold gender discrimination in property is clearly in front of this court as a constitutional equal protection violation, and is surely where they haven't briefed that we were wrong on any of that. The stricter judicial scrutiny comes down, so they have waived any decisions against it. Therefore, this agreement seems clear. My constitutional rights have not somehow been rolled back so that they could be denied or abridged.
Okay.
So basically my rights were ignored because it was given to, my home was given to me of title. That title was been ignored since the case started. Wells Fargo ignored it, and then the third party ignored it when they came to my door asking for my ex-husband to sign a paper.
I have read your briefs in the
Okay.
background of the case, and so I understand your recitation of the facts. But I have a sort of a different question, and that is all of those arguments that you're making right now.
Right.
Your counsel here says they're not directly before us at the moment because there was a summary process judgment that was entered. Do you understand what I'm trying to say? So there was a summary process judgment,
Yep.
and that's the judgment from which you wanted to appeal, correct?
Right.
Okay. And in order to appeal from that, you were required or ordered to set an appeal bond in order to pursue your appeal.
Well, that's what I was explaining, that it didn't get sent up, so another judge had to send it up.
Right, but
because
eventually it
ignored.
was, right? Right, and eventually, as you set forth, that your notice of appeal was accepted by the court, et cetera.
Exactly.
And I'll talk to the counsel for the other side about that. But let's presume for a moment that the notice of appeal is okay, all right? So you still had to set an appeal bond to keep going forward, right? Okay, and that has, when you talked before about receiving some help, that appeal bond has never been established, right? No one's ever paid that.
Because an appeal bond is set, because it has to go back and it has to accumulate the money, but if from the beginning, the case wasn't, they said that they didn't want use and occupancy or anything, so there was no appeal bond from Judge Winnick. He said that I didn't have to pay use and occupancy. And so that, therefore, there's no bond that can build.
Okay, so you don't have a recollection of a $26,000 or so bond being placed for the appeal to continue forward?
Yeah, that's the appeal that was ignored, that wasn't sent up.
Okay.
And Your Honor, I also want to point out with the, when I filed for the summary judgment case of the 1132, the plaintiffs didn't, they didn't argue it. They didn't do it. They didn't do a brief.
Okay, all right.
So that reflects on the case we're speaking of now, the
Okay.
0922.
All right. Okay, well, thank you for answering that question.
You're welcome.
All right. Do you have anything else that you want to bring to our attention with respect to this appeal before we talk about the other one, the one ending the 22-922?
Well, I want to state that, as a summary judgment is not valid, he concedes all of the arguments that's void. I pointed out in my reply brief, he can't use a later case on a different subject to get her, like, he can't add another subject to something he didn't finish.
Okay.
Like, he let that go. He didn't put an argument in for that, so we can't restart something.
Right. I think your position is, you're saying that's waived. That's what you're saying.
Yes, it's waived.
Okay. Mm-hmm.
So he'd violate the court rules in due process because Silva waived it.
Okay. All right. I'm going to see if the panel has any questions about this appeal, and I see none. So if you're done with this appeal, we can hear from the other side now, but I don't want to. Does that make sense to you?
Yes.
Okay, all right. So just don't go anywhere. You can stay right there, and we'll restart the clock once you take the podium.
So I just will.
You just stay right here, because you're going to sit right here, yeah, because then you'll argue your next case after we hear from counsel for the appellee. All right. You can sit down.
May I proceed?
You're,
Good morning, Your Honors.
Good morning.
May it please the Court, my name is Tom Vukmirovitz. I represent JAYNE
I'm
Silva.
already going to have to ask you to see if you can pull that microphone closer to you and use it. You may have to lean over a little bit. I apologize, but I'm having a
is
hard
that
time
better?
hearing you. That's much better.
Okay, I apologize. Good morning. As I tried to state earlier, my name is Tom Vukmirovitz. May it please the Court, I represent JAYNE Silva, the appellee in this case. So regarding Appeal 22P922, just because you're pro se does not change the rights of appeal that a party has. And this appeal is limited clearly to the issues as noted in this appeal's docket entry, specifically docket entry number 22 from September 22 in 2022, which is whether or not the single justice in her September 8th, 2022 order striking the appeal from the single justice order affirming the Housing Court Appeal Bond order was correct. And the second issue was whether or not the Housing Court's order allowing a motion to dismiss the appeal for failing to comply with the appeal bond order was correct. So regarding the first issue, Your Honors, there is longstanding case law that there is no right of appeal from the order of a single justice. And as reflected in the second case, there are some exceptions, for instance, for undecided issues of law, but this is not one of those cases. There's nothing undecided about what happened here. And I'll just briefly go through the chronology of the case.
Well, when we say undecided, we don't necessarily just mean undecided about the case, but whether or not there's substantive issues that are being raised that are undecided, correct?
That's what I meant. There's no
And you see none?
No, there's no
But
peculiar
let me
out of the
just let
ordinary.
me ask you, because I can anticipate your answer, but do you think that it's wise to wait until the Supreme Judicial Court renders its decision in Frechette v. Brown before we issue a decision in this case?
I do not, and I was going to get to that at the last part of my
Oh,
argument.
sorry about that. I didn't mean to preempt you, but it seemed to come up, so.
No, I was going to address that, but I was going to, before you mentioned that, when you were addressing Ms. Stanley, I was going to bring that up in the context of this pending motion to stay the execution, because last September, my client had yet another move scheduled. Right before the scheduled move, there was an urgent motion to stay that was filed by Ms. Stanley.
Last September, right?
Yes, and I responded to it, articulating and distinguishing the cases, including Frechette, from this case. And I understand from a status update that decision on that motion has been reviewed to the full panel, so I just ask that Your Honors address that motion too, since my client is waiting again for another 6 months before being able to use the execution. Frechette, Your Honor, was a case that was reported up by a single justice, I believe, from
correct.
a housing court appeal bond order where the tenant was found indigent, as was Ms. Stanley, but had a non-frivolous
defense.
ground of appeal, which in this case, it's been decided twice after de novo review by the single justice and also by the housing court judge, that there is lacking that in this case. So for that reason, mainly, there's no reason to delay a decision on an appeal that really has been decided lacks merit. In this case, Your Honor, the cases make clear that if you do elect not to pay you have two options. You could either pay the appeal bond, including any interim use and occupancy orders pending the appeal, and if you do that, then you have full appellate review of the underlying judgment. So, for instance, all of the issues that she raises with the foreclosure and anything else involved with that judgment, she would have appellate review of. However, she chose the second option, which is not pay the appeal bond, not pay the use and occupancy order, but then have a limited appeal only as to whether or not the dismissal of the appeal was correct. And
So what if we were to determine, hypothetically, that the dismissal of that appeal was incorrect? Okay. Then is the underlying appeal from the summary process judgment reinstated with all of the issues that have been raised and so far, as you put it, not before us right now in this appeal?
if that's before this court, if you decide that the dismissal was
Then we would go
an error,
ahead and
then
address the other issues.
I-
Okay.
yes,
All
and-
right. It
and that's
doesn't
why
have to
I-
go back someplace else and have a new appellate, appeals period go forward.
I suppose, but that's why I also
I
addressed
realize,
partly
I
in my
recognize
brief.
that. That's why I wanted to
Yeah.
double check. So as
Yeah.
far as you were concerned, hypothetically, should we, for a reason, determine that the case should not have been dismissed, then we would just go ahead and go forward and examine the issues that were raised that challenges the summary process judgment in the first place.
Yes, but
Okay.
I also.
Wouldn't want a chance to brief the merits of the
Well, he did.
underlying case?
Your Honor, as I attached a copy of the summary judgment decision. It's
Yeah.
very thorough. It addresses, number one, there was res judicata principles that were accepted by the court because my client was substituted for Wells Fargo in its summary judgment order against Ms. Stanley and her children. But nevertheless, even though accepting the issues already concluded via res judicata, Judge Winnick nevertheless went through the whole record as it pertained to the foreclosure and concluded that Wells Fargo had strictly complied with the foreclosure.
Rest on the
Yes,
judge's decision.
I don't think
Okay,
there's
and that's
anything
fair.
else, yes. And also, he addressed the issue of this title claim because, as noted in the record, and as is contended by Ms. Stanley, her ex-husband had title to the property vested from him and transferred to her via probate court proceeding. But as noted in the decision, the changing of title does not do anything to the mortgage, and therefore Wells Fargo had authority and properly foreclosed on the mortgage. Having foreclosed on the mortgage, they got summary judgment, and my client bought the property from Wells Fargo shortly after the second summary judgment back in June of 2020. Your Honor, the appeal bond issue was heard. It was decided, as Your Honor indicated, the appeal bond of $26,400 was set because there was nothing presented suggesting that there was a non-frivolous ground of appeal. The only arguments, as noted in Judge Horan's appeal bond order from the Housing Court, Ms. Stanley contended my client was not a bona fide purchaser, which was noted as being unsupported. She contended that my client did not have superior title. Again, that was unsupported and subject to res judicata and a thorough review by Judge Winnick. And then third, that she needed to protect her living situation and keep a roof over her head. Judge Horan found that those reasons were not enough to establish a non-frivolous ground of appeal. Therefore, under 239-6, whereas this wasn't a tenancy, this was a post-foreclosure summary process, she went back to when my client acquired the property and used the same interim use and occupancy amount that Judge Winnick had found earlier in the case of $1,100 a month, and multiplied that out for the number of months. It was due to be paid the following first of the month, which was July 1st, 2022, and that was never complied with, and therefore the appeal was dismissed. The reason why I contend that there was no abuse of discretion for the order dismissing the appeal and no clear error of law was because Ms. Stanley actually got two bites at the apple. Upon the failure to post the interim use and occupancy or the appeal bond by July 1st, a motion to dismiss the appeal was filed on July 2nd. That was heard, and on July 13th, Judge Winnick issued an order finding that there is basis to dismiss the appeal, however, stayed that order or continued that finding and ruling until July 26th or so, 2022, to allow Ms. Stanley to make some payments. At that point, a third party had come in and
Made two payments, right?
offered to make payments, yes. And this notion of my client not complying with any kind of government payment, I'm not sure where that's from, but if to the extent it addresses that issue, I recall directly telling this third party that you're free to make these payments, but that's not going to stop my client from the, I just wanted them to understand that they're not making payments for futile reasons. But they did make the payment for July and August, and that's why in the further order, the second dismissal order, if you will, on July 27th, Judge Winnick allowed the motion to dismiss, and but stayed levying on the execution until September 6th because he found that the payments were made through the end of August. There was a subsequent motion to stay the execution, and that was extended through most of September. And that is basically the crux of this case. Unless you have any further questions from me,
I don't. No, I don't. Thank you very
Thank you.
much. So I'm going to ask you to retake your seat, and I will hear from you with respect to appeal number 23437. So just to be sure that the record is clear, this is case number 2023-0437, and against Jane Silva versus Sherry Stanley. And Ms. Stanley is here to argue the case. Thank you.
I am. So, as you said, it kind of goes with each other, but it's a different situation. So, in the plaintiff's reply brief, I put in a motion this morning, I don't know if you've seen it or if you guys accepted it, to strike his pages through 9 pages 12 down because they were relevant to the case, because he lacked on the other brief. So whatever he wrote in this reply brief to this case is irrelevant to anything because he made everything waived. Like
Okay.
everything just got waived because he didn't continue or he didn't make any statements. He just didn't answer anything I said.
Okay, so you think, your view is that the brief in this case is non-responsive, I'll put it that
Yes,
way.
I
All
am,
right.
yes.
And so, don't want to put words in your mouth, but I
Yes.
think you're telling us that you think you prevail because, on that basis.
Correct.
right? Can you just tell me a little bit about this case? In other words, what's been argued is that this case is moot, which means this case is no longer needs to be decided because the circumstances have changed.
Right.
And this is a case that involves a requirement for you to make use and occupancy payments pending a trial, right? Before
Right.
the trial. And then there wasn't a trial, but there was a summary judgment entered, which is in lieu of a trial. Is that right? Okay.
Right.
So why does it matter what happened before that date, in your view?
Because that's how the case started, and I didn't get my rights in the first case. It just got,
Okay.
it's so frustrating, Your Honor.
Well, you've brought everything to us. We have all the records, we have all the briefs, we have everything, and I don't want you to take any of our questions as being more frustrating. We
Right.
just want to be sure that you have the opportunity to tell us
Right.
everything about the case that you
Well,
want
the-
to.
From day one, since the third-party purchaser bought my home, they knew the title was not in, that the title was in my name. It got ignored. As I said, the third-time party purchaser, which they came to my door and told me they bought my home, and they said they buy all kinds of homes around Worcester. So they have plenty of property. They're known for buying homes. Second of all, he said, I need Joe Stanley to sign this paper so the mortgages can get put in my name. And I said, he has a restraining order, he almost killed me, the title's in my name, and the only reason why, Your Honor, I don't have a mortgage is because Wells Fargo ignored me.
I saw that in there, right?
So I never got a free chance, I never got a chance to pay a mortgage. And when people say, oh, you just want a free house, Your Honor, that's not true. I wanted a home for my family, and that's why the judge gave me the opportunity. Wells Fargo put me in foreclosure. They wouldn't talk to me. They've had all the information mailed to them about my murder, the title change, the judge saying that the mortgage to be put in my name to give me a loan mod. It was totally ignored. I didn't have a chance from day one with Wells Fargo, and then they stepped in the shoes of Wells Fargo, and they did the same thing. And when they bought my home, it was during COVID. When it was the shutdown, you couldn't pay any, people couldn't come on your property. They kept coming on my property with no masks. They came in my home. They had a realtor come in my home without a mask, taking pictures. It was just a nightmare. They took advantage of the courts closed and put my home online and sold my home without me knowing. I had a friend tell me, your house is for sale. During COVID, it was the scariest thing. And my kids are petrified. They're so scarred from this whole thing. So it's like, I never had a chance to pay for my mortgage, or I would have, Your Honor.
Okay, all right. Well, we appreciate that. Now, I'm just going to see if we have any other more specific questions
Okay.
about the record or anything, because I don't have any. I'll just check with the panel. None here and none here. So we have your briefs, we have everything. We, there's, as you said, there's a lot to read, and we will
And
review
I've
it.
learned a lot over the years. I feel like I could kind of be like a lawyer.
Careful what you wish for.
Thank you,
All
Your
right,
Honor.
thank you very much. And you can stay right here and stay seated while we hear from the other side, okay?
So, good morning again, Your Honors. Similarly to the first case, this appeal is limited to a confined issue, and that is whether or not there was a correct ruling affirming the lower court's order declining to include into the extra cost and fees of the indigent court cost law interim use and occupancy payments. And similarly, Ms. Stanley appealed that order from the housing court to a single justice, which affirmed the lower court order. Single justice then an appeal was taken from the single justice order, but there was a finding from this court's panel that even though the single justice was correct.
It was sent to a panel, yeah.
Yes, and even though the single justice was correct in the ruling that there is no appeal of a single justice order, this case presented an issue of a question.
Right, now, in that case, that was another panel decided. They indicated that they were not taking any a view on whether or not this case would be moot by the time it was actually briefed and heard by us.
Yes.
And you take the position that it is moot, is that correct?
It is moot for exactly what you referenced earlier, that summary judgment rendered moot this interim use and occupancy payments because that was only in place.
It was only in place up until such time as there was a judgment.
Until there was the jury trial and a judgment, yes, because in housing court typically it takes longer to have a jury trial.
And there are no damages, and it wasn't incorporated into any damages award, was it? The unpaid use and occupancy.
The judgment had no damages award because in the summary judgment decision, Judge Winnick claimed that there was no account annexed. There was never any tenancy. My client just wanted possession of the property back. Okay. However, the appeals bond order is different because that can go back to the damages that my client has incurred while being deprived possession of this property that they purchased from 2020. So in this case...
And just to state the obvious, but I want to be sure because it is a complicated procedurally, is that since your position is that the issues raised in this appeal are moot, you would also say that we certainly don't need to wait for fresh... I don't want to put words in your mouth, but I see you shaking your head. It would make sense therefore, that we wouldn't need to wait for Frechette v. Brown to be issued by the SJC.
Yes, for that reason, and also because that presented a different issue that had a meritorious or...
As you said before,
yes,
right, okay.
Yes. So in this case, Your Honor, I would argue, as you indicated, that the whole issue is moot. If Your Honors do not decide that the issue was moot, then there simply is no... Number one, to waive the use and occupancy payments, especially during the appeal process, will be incredibly prejudicial to my client, a small-time landlord who would be getting nothing while this appeal is pending that has been twice adjudicated to lack non-frivolous grounds, while they have to pay the carrying cost of the house, any mortgage, water and sewer, insurance, taxes, the like. The second part of the argument is that if not waived, then it should be paid by the Commonwealth or substituted by the Commonwealth on the indigent court cost law. That there's just no mechanism to do that. I didn't file a responsive brief to the appeal of the single justice order that resulted in the 23P 437 decision because as I stand before you, I'm kind of at a loss. I represent my client who, if you or the Frechette court decides that interim use and occupancy is part of the extra costs that are compensable, then my client stands to get a lump sum payment going back to 2020, which they obviously wouldn't be opposed to. However, there's no mechanism for that. Unlike, I do a court-appointed criminal defense, so I'm very understanding and appreciative of indigent representation throughout the court process. But there's a system set up. There's CPCS. If funds are needed to address costs, then the court allows it or denies it. But if it allows it, then CPCS pays those costs. I'm not sure where this money would come from. The state hasn't appropriated any money for these types of...
Maybe the SJC will tell us.
Perhaps, but I think it would still have to come from the legislature creating an agency.
Make a suggestion.
Yeah. But so that there is no mechanism in place. There's certainly balancing the financial harm to both parties, as the lower court is allowed and probably required to do under Davis v. Comerford. That would just be completely one-sided if the landlord if tenants are allowed to waive interim use and occupancy. In this case, it doesn't even rise to the level of a landlord-tenant. It's like my client, there was never any tenancy between them. In terms of in terms of any claims against what Wells Fargo did to Ms. Stanley or said or acted towards Ms. Stanley, those are directly against Wells Fargo, not my client, and whatever claim she has against Wells Fargo could be addressed directly against Wells Fargo. So I have nothing further to add unless Your Honors have any questions.
Questions here? No. Thank you both very much.
Thank you very
All
much.
right. We'll take the case under advisement, and we'll try and get back to you as soon as we can. All right, thank you. All right. I'm going to call the last case we have on for today, which is R. Scott Murray versus Stephen A. Meyer and others. Case number is 2023-0799. All right, and so we have one person arguing for the appellant, and the appellee is splitting their time 13 minutes and 2 minutes, correct? Okay, great. Okay, thank you, Counselor. It's afternoon now. Good afternoon.
Good afternoon, Your Honors. May it please the Court, Shepard Davidson on behalf of Scott Murray. What Mr. Murray needs to show in order to prevail in this appeal is that he has some evidence, the proverbial toehold, that the offer to purchase in this case contained all the material terms and that Attorney Meyer, the seller, intended to be bound thereby. The leading case, McCarthy v. Tobin, says the controlling fact is the intention of the parties. And Mr. Meyer's counsel agrees with this. At oral argument, his counsel said, if you look at the cases, regardless of whether it's a buyer or a seller, the court is trying to manifest the party's intent at the time the offer was signed. So if after the offer was signed, Attorney Meyer came up with the idea, well, geez, maybe I should consider using this paragraph 51 language, which is exactly what we think happened in this case. That doesn't help him. And again, they agree. At oral argument, his attorney said, if the party, regardless of buyer or seller, later reneges, that's when the courts say, you can't later renege. You had the intent to sign when you signed the offer, and therefore, we're going to enforce it. The basic fact pattern here, as I think you know, is one that's repeated itself many times over the past 50, 75, 100 years. Buyer or seller and buyer number one enter into an offer to purchase. Things break down at the purchase and sale stage. The seller then sells to buyer number two for more money. Then buyer number one sues saying, hey, I had a right to buy this property based on the offer to purchase. Now, in this case, the defendants say that Attorney Meyer couldn't possibly have had an intent to be bound by the offer to purchase because it didn't include this paragraph 51 language. And it's essentially a syllogism. He says, I'm a fiduciary, so I have a duty to get the best deal for the estate, which is who he's representing in this case. I need the paragraph 51 language in order to get that best deal. That wasn't in the offer to purchase, so obviously I couldn't have intended to be bound. But here's the problem with that argument. So paragraph 51 basically gives the seller an option. Even though there's a contract to sell to Mr. Murray, he's got an option at any time before closing. 1 minute before closing, somebody else comes up and offers a penny more, then the seller can sell that property to somebody else, and Mr. Murray is left with nothing, and he's wasted his time and his investment having his money tied up. So plainly, if you have paragraph 51 language, some buyers are going to say, I'm not interested. I'm backing away from this. And Attorney Meyer actually agreed with that. When I asked him in his deposition, wouldn't you agree with me that a buyer is more likely to sign a purchase and sale agreement if you don't have paragraph 51 in the document? Answer, yes. So it's not the case that you need paragraph 51 in order to get the best deal. That might actually impede your ability to get the best deal. In fact, Attorney Meyer testified that 5 times before this, he had sold property as a fiduciary. Only 3 times had he employed paragraph 51 language. Mr. Murray testified that he had bought 3 properties out of estates, and he'd never had to have paragraph 51 language foisted upon him. In fact, the purchase and sale agreement with Jenna Harrington in this case, the one they want to enforce, doesn't have paragraph 51 language. So the fact that you must have this language in order to have an intent to be bound doesn't follow as a matter of law, which is what they have to show.
But isn't the primary question here whether there is a binding offer to purchase, correct? And your client didn't counter-initial the changes that the seller made to the offer. So how do you get over that problem?
Sure. He absolutely didn't initial in writing. He assented to it, Okay, you can assent to a contract other than by writing, by your conduct. He acted in accordance with it. He put forth another $240,000 deposit, which was called for in the offer to purchase. So our position is he absolutely assented to that change.
I thought he put forward that $240,000 after signing the PNS with paragraph 51 language in it.
He did. That was.
Okay, so why isn't that assent to paragraph 51 and not to the offer?
Paragraph 51, well, that document was not a contract, okay?
I understand, but so he doesn't, as Judge Toone pointed out, he didn't counter-initial the offer to purchase or sign it.
He did not sign
And
it.
you're saying, well, he manifested his assent by tendering the deposit, but that was in response to the PNS that was sent over with the paragraph 51 in it.
That was the time called for in the offer to purchase. It didn't, the offer to purchase doesn't say you have to put the $240,000 now. You put that forth with the purchase and sale agreement. It's consistent
But
with
I
that.
don't understand how that's not then assent to paragraph 51 when he signs the PNS and tenders the deposit.
It's not assent to paragraph 51 because that would have to be a contract, that purchase and sale agreement. That purchase and sale agreement was not a contract because Attorney Meyer testified very clearly. I asked him, I said, when Scott Murray signed that purchase and sale agreement, sent that deposit back, did that make it a contract with you to sell to him? He said, oh, no, that wasn't a contract. That could only be a contract if he signed it and I signed it.
No, I agree. The PNS was never became a binding contract because it wasn't signed, but we're trying to decide whether the offer was a binding contract.
Right.
And I don't see where there was ever offer and acceptance, because there was no acceptance until the offer, the deposit was tendered.
No, there was acceptance because, well, first of all, the only sort of change in there was striking that language from the standard to mutually agreeable. Okay, I think we can all agree to that. All right. Now, that was not a material change. You go back, McCarthy versus
You're
Topin.
saying the offer was accepted at that point when he countersigned the offer with the strikeout? And
Yes, absolutely it was accepted. It had all the material terms. Again, the question then is, did he intend to be bound? And so when, now Attorney Meyer says, well, I didn't accept that offer. I rejected it and submitted a counteroffer. That's what he calls it, okay? But that's not what he said at the time. When he sent it back, the day he sent it back to his broker, he didn't say, here's a counteroffer, I rejected this. He said, attaches the executed accepted offer. He's saying, I accepted the offer at that point.
But that's his own that's not evidence that your client ever saw at the time, right? We have to look at whether or not the actual offer, there was offer and acceptance on that. And your position is, there was offer and acceptance when the seller signed it and changed the language because the language that he changed was not material.
Absolutely.
Okay.
And Mr. Murray said that. He was very consistent about that. He said, I didn't think that was a significant change. His real estate lawyer who testified in this case, he testified that wasn't a significant change.
So
that
your
was
position
acceptance.
is that changing it from a standard purchase and sale agreement to
Mutually agreeable.
a mutually agreeable, that's not material.
That's
Seems
right.
material.
Absolutely.
It's not material?
Absolutely. What you said
No,
absolutely.
it's not
I think it's absolutely a little
Yes.
quickly there.
My position is that's not a material change. And that was acceptance when Attorney Meyer did it. And again, ultimately, with any contract, you have to look to the intent of the parties. What did the parties intend? Okay? And again, you've got, now, the only one that's saying that was a material change is Attorney Meyer. That's what he's saying now. But at the time he didn't say that. He said, I accepted it. Okay? And then the same
Said
day,
it to whom?
to his broker, he said,
Okay,
here's,
why is that relevant?
because it shows his state of mind. He said, I accepted.
We're looking at the objective manifestations of assent, right? So if I make an offer and someone alters it to say contingent on some future mutually acceptable agreement, to me, that's not an accepted offer.
Well,
It indicates there are still things to be decided. And isn't it the case, I mean, it's undisputed that your client was told that the property would continue to be showed even after the offer, right?
that's correct.
So what's the purpose of continuing to show the property unless they're going to accept additional offers?
To accept backup offers, because
Yeah,
as we
right.
all know, many times transactions fall apart. And that's what he testified to consistently. And again, that's a question of fact. We're here on summary judgment. And so I think it's objective to say, Attorney Meyer, sent an email saying I accepted the offer. I think it's objective to say the same day that he sent that back, he sent an email to Ed Rubin, who was the beneficiary of the estate, who was living at the house. Okay, and Mr. Rubin said, basically he was concerned, I'm not sure Mr. Murray's really going to buy this property, and Attorney Meyer says, a mutually agreed upon offer is a binding contract under the laws of the Commonwealth of Massachusetts, regardless of any issues arising under a subsequent purchase and sale agreement. I think a reasonable interpretation of that, given the context, is that he knew he was bound. He accepted it. And there's no paragraph 51 language. There's nothing else material at that time. That's what matters. What was in his mind at that time? That's an objective manifestation of his assent.
It wasn't manifested to the other party.
That doesn't matter. That's
Why
the biggest red herring in this case.
Okay.
Why?
Explain why.
They say their biggest argument is, well, all of these admissions, okay, Mr. Murray didn't know about them. All right? We're not using them because they manifest assent. Assent was signing the document, sending it back, saying I accept it. That was the assent. This shows his intent. Did he intend to be bound by it? Did he believe it included all the material terms in the document? Now, on March 19th, Attorney Meyer gets an email from the broker of buyer number 2, essentially Jenna Harrington, and says, and that broker wanted to know, is Attorney Meyer ready and able to sell the property? And that buyer also says, well, I've made an offer, I've made an over list price offer, okay? So what did Attorney Meyer write back? He didn't write back, well, I'm going to have paragraph 51 language, so if you made a higher offer, you're going to get the property. He didn't say that. He said, I have obligations associated with the accepted initial offer. That shows his intent, that he intended to be bound by this. And then we get to...
Well, what does obligations mean? It could mean different things, right?
That it could be, and we're at summary judgment. Certainly reasonable to think obligations mean I have binding contracts.
Well, it's an exchange between Mr. Murray and his broker, right, where the broker says there have been other offers.
Yes.
But, you know, you're good because one of the
likes you.
beneficiaries likes you, and so be patient.
Yes.
And he writes back, sounds good. So why isn't that evidence that well, he knew the property would continue to be showed and that there might be other higher offers?
That is evidence of that, Your Honor.
So then,
They don't get summary judgment because there's some evidence that goes against my case. They can only get summary judgment if the only conclusion you can reach is in their favor. So let me get to that by this point right here, okay? There was a very important exchange at summary judgment between Judge Callan and Attorney DeValis, who's representing Attorney Meyer. Judge Callan said, so I take it he said, Meyer says that when he did not intend to be bound, when he signed an initial, I take it Meyer says he did not intend to be bound when he signed an initial deform, right? And Attorney DeValis says, right. And then Judge Callan asked, but what does he say about the letters and the emails? A mistake? And the first part of the response is, they were poorly chosen words. But then at the end, here's the response from Attorney Meyer's counsel. So I just think there's other evidence that occurred at the time that Mr. Meyer signed the offer to purchase that indicates that it was not his intent to unconditionally accept the offer to purchase. So you have some evidence that maybe says it does and some that says it doesn't. Okay, we all know from first-year civil procedure, if you've got evidence on both sides of a key issue in the case, that creates a genuine issue.
Right before that, he or she, was it she? She
Yes.
said that that evidence wasn't relevant because they were not objective manifestations of assent.
And Judge Callan asked her, well, are they going to come in? Are they admissions? And she said, yes, they're going to come into evidence.
But the position, the underlying position that Meyer's attorney took was that these were not relevant because they were statements made to third parties that were unknown to Murray. So I don't see how this is some sort of binding judicial admission.
Well, that position is just flat out wrong. The purpose of those admissions is that they show his intent, his state of mind, okay? And they do. Whether Mr. Murray knew about them at the time or whether he never knew about them, they still show his state of mind. Attorney Meyer could have written in a journal, you know, I signed this today, and I really believe I'm bound to it, and it has all the material terms. I think that would end the case for us. Now, Mr. Murray doesn't have to know about those things to end the case, okay?
But I think that the fundamental problem here is that you need to have some offer and acceptance, right? And you change, the language has changed from standard P&S to mutually agreeable. And And that seems to be a change. And you're saying, no, there was other evidence of acceptance. And we have to ask you, what is the objective?
I'm not saying there's other evidence of acceptance, Your Honor.
Okay, manifestation of intent.
Yes.
To enter into what is that? What is the objective? Not just what Mr. Meyer is saying to third parties, but what is that that's out in the open that makes clear that the offer was a final contract?
Well, let's look at what Attorney Meyer said on March 17th when he sent a letter to somebody who Ed Rubin was trying to buy property from. Mr. Rubin said, hey, I want to make sure this buyer knows that I'm going to have money soon because you're selling my property. Okay, on March 17th, Attorney Meyer writes a letter to somebody he knows is going to rely on it, and he says, I have accepted an unconditional offer to purchase the property. And he sends the offer to purchase. How does that not create a question of fact as to whether or not Attorney Meyer intended to be bound and it had all the material terms? Paragraph 51 is a condition per se. He says, I've accepted an unconditional offer. He's telling us, I did it. And then after he did that, he says, whoops, I better include the paragraph 51 language because I want to get a better deal. That's certainly reasonable. We're dealing with summary judgment.
It doesn't have to be objective manifestation of intent that's conveyed to the other party, not to someone by letter, someone who's not involved in the transaction. That's you know, how does Meyer know that Murray has accepted this as a contract?
Because he signed it and sent it back. The question then is, what does that mean? Okay, what did he mean when he signed that document and sent it back? All right? And what he says now it means is, I rejected your offer and I made a counteroffer. We said, no, you're making that up. At the time, you put in mutually agreeable, but that wasn't a big deal, okay? And how do we know that? All your other conduct and everything that you said. So that was his manifestation of assent, was signing it and sending it back. If he didn't change that language, we wouldn't even be here, obviously. Okay, so the question is, what did he mean when he put that language in there? And there's a material issue of fact on that.
Just a second, because your time is up, and I don't know if we have any other.
Oh, I apologize.
Don't need to apologize, and of course, you can rest on your brief, and nothing is waived, and thank you for your argument.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the Court, Sarah Toronto-Flores on behalf of the co-defendant Jenna Harrington. I'm going to take 13 minutes to address the substantive issues. My co-defense counsel, Mr. Toone, is going to address the motion for fees. That's how we've divided our time today. And you've heard Mr. Davidson, plaintiff was principally relying on two different arguments. The first being that McCarthy v. Tobin controls here and that the Superior Court should not have found that the offer to purchase was an enforceable contract based solely on the fact that the parties anticipated a future contract. His second principal argument is that the Superior Court ignored 4 pieces of evidence that they contend created genuine issues of material fact, and thus it should have been a triable case, not decided on summary judgment. They're wrong on both counts. And I think I can address all of what Mr. Davidson said in his points by first noting that the facts in McCarthy v. Tobin, which did, in that case, the offer contemplated, like this one, a future agreement. However, they're vastly different. There's no evidence, and McCarthy v. Tobin was both an appeals court case and an SJC case, and if you look at the appeals court decision, you get the facts of the case. There were negotiations during the offer in which the price and the identity of the parties, the closing date, all of the material essential terms were determined, but no other discussions, none of this background evidence. There was no estate involved. The facts that I'm about to go through weren't present or articulated in that case. Instead, suddenly at the purchase and sale agreement stage, and only when they were looking specifically to the standard language in the standard purchase and sale agreement, did some disputes arise relative to that agreement. And those included requirements for good title, the seller's risk of casualty, mechanics liens, parties in possession, the standard provisions that are ministerial and non-essential terms of the bargain. Every single case has them. In McCarthy v. in this instance, in contrast, the judge did not rely solely on the fact that Mr. Myers crossed out the standard standard and inserted mutually agreeable. Instead, he found 3.5 pages, almost 4 pages, of subsidiary findings that provide much more context as to why that action in crossing out standard and inserting mutually agreeable meant that there was no meeting of the minds of the parties. They did not intend to be bound at the offer stage. They instead intended at a future date to be bound by a mutually agreeable purchase and sale agreement. They did not intend to be bound by the offer. And these facts start not only before the offer, but during the offer creation itself and then after. And I heard Mr. Davidson say those facts don't matter, that we only look to the point of the time of the offer. But that's not true. In our case law, in our brief, we identify numerous cases, mostly from this court. In fact, all 4 of the ones I'm about to review are from this court, which ask and say it is appropriate for the court to consider evidence that occurs not only during the offer stage, but after, at the purchase and sale agreement stage. Blomendale versus Imprescia, the evidence at the time of the purchase and sale agreement not included in the offer was a dispute regarding warranties about rent rolls and personal property. It wasn't contained in the offer. That came up at the P&S stage. They weren't even talking about it until the P&S stage. That was held enough to demonstrate imperfect negotiations, no meaning of the mind, no enforceable contract.
Can we back up a second? So it seems to me your best argument is that there was no meeting of the minds with the offer. Is that your primary position?
No intention to be bound by the offer.
And that's primarily because your client changed the language from standard to mutually agreeable.
I do not represent Attorney Meyer. I represent the buyer, Jenna Harrington. Mr. Sooney's client changed that. And no, that is not my contention. I rely on the facts going into it and the facts after that show that there was no meeting of the minds, not solely that he crossed out that language. And I can review those
Is that
facts.
a factor then? Then what is your position? There wasn't a meeting of the minds because there were other terms that were subsequently would have been covered by the P&S? I don't understand your position.
The context of all of the facts, and maybe reviewing those facts will help with that context.
No, I'd like just try to focus an answer on it. So what exactly is the reason that there wasn't a binding offer?
Because the parties knew when they signed the offer to purchase that this was being sold by an estate and that there were fiduciary obligations that required this personal representative to accept offers that were higher.
What is that principle from? That seems very strange to me, that fiduciaries can't enter into binding purchase and sale agreements. Is that true? Everyone wants to sell their property for the highest value, including fiduciaries, right? But there's a value into entering the P&S agreements because you set the terms of a contract and then you proceed towards closing. So I don't understand that fiduciaries are somehow, it's not possible for them to enter into closed P&S agreements. Is there something that I'm missing? Because all you rely on is Mr. Meyer's own testimony here, which he didn't seem very persuaded by the point.
No, we rely on 2 cases that we cite, actually, Onianian versus Leggett, 2 Mass Appeals Court, 623, 1974, is quoted in both of our briefs. And in that case, the appeals court recognizes that the fiduciary and personal representatives of an estate particularly have a duty to obtain the highest possible price for the property, and that is a
Does that
direct quote
foreclose them from
Onianian.
entering into a P&S?
Excuse me?
Does that foreclose fiduciaries from entering into a binding P&S?
They have to get a license to sell. Paragraph 52 required a license to sell from the probate court. When you go to get a license to sell from the probate court, you must represent to them that you, as a fiduciary, have done your utmost best to ensure the highest price for the property. That's why these are routine conditions that are included.
And that's not possible to exercise that duty and still lock in a price, a fixed price in a P&S before closing.
Like any court proceeding, you have to demonstrate to the court what those efforts are. So there can be different efforts to demonstrate how you obtain the highest and best price. These provisions are routinely used to show that the free market being the best way to obtain, to ascertain what is the highest price for the property. You entertain those offers all the way up into the closing, or at least until you go get the license to sell from the probate court. And that is in the cases that cite Newhall Statement of Estates, 4th edition, section 120, and the other case that we cite in our brief as the basis for these fiduciary obligations is Mulcairn versus Smith. That's a Superior Court case, same exact facts
It
again.
still doesn't seem to support your point, which is that fiduciaries cannot enter into binding purchase and sale agreements. That just seems that doesn't follow. The duty to get the best price, to do everything you can to get the best price, doesn't mean you can't enter into a P&S that fixes the price before closing.
I think at the offer stage, there's a distinction here. We're saying that the offer stage was not binding because at the offer stage, he was continuing to market the property. Everybody knew he was continuing to show the property and going to entertain higher offers. You're asking at the P&S stage. I think there's quite a difference. Between being able to enter into a mutually binding and conditional offer. Again, paragraph 52 of the purchase and sale agreement said that he had to get a license to sell. So it's a binding purchase and sale agreement. It's certainly binding. If he got the license to sell, he would have to sell. But as a condition of closing, paragraph 52 required him to get to that license to sell, and that requires a showing to that court that he used efforts to get the highest and best value.
Okay, so going back to why the offer to purchase was not a binding contract. Your argument is?
The offer to purchase was not a binding contract because, and I'll review facts both before, during, and after, if you'll bear with me. Before the offer was even submitted, it is undisputed that Mr. Murray was aware it was being sold by an estate. The offer was addressed to an estate. He concedes in the Superior Court details this in their findings, which were based on the undisputed statement of facts. Harrington's statement with responses, where it says undisputed, are in the Record Appendix, Volume 1, page 66, starting at page 66. Paragraph 8, Murray concedes that he was expressly told by his broker at the time that they were formulating the offer that the estate would have to continue to show the property, but Murray felt his price was high enough to withstand any other properties. He was aware going into this that they were going to continue to show the property. The offer itself, again, it was addressed to the estate. He was quite aware. When Murray did not accept it unequivocally, as occurred in McCarthy v. Tobin, by the way, instead he crossed out the language standard form and changed it to mutually agreeable. He didn't, in McCarthy, they didn't cross out the language requiring the standard form. They added a further condition contemplating a future agreement. I think that's a small nuance, but it's a nuance that's a distinction with importance. If you know other offers are going to be entertained and the person who's entertaining those offers crosses out that you shall be required to sign the standard P&S and instead adds mutually agreeable, that should have put you on notice as an objective manifestation of conduct that you didn't intend to be presently bound by the offer to purchase, but instead that you intended a future agreement to bind the parties.
I'm sorry, what is the difference? McCarthy had language in the offer that said, subject to a purchase and sale agreement satisfactory to buyer and seller, correct?
Also, yeah.
Yeah, is that correct? Which seems very similar to mutually agreeable here.
It had further provision further up, if you look, that said the parties shall, by such and such a date, sign the standard form. That was not crossed out. They shall sign the standard form. That was not crossed out. Here, again, it's maybe a minute distinction, but where you have these precursor facts that put the parties on notice that this was an estate and it was going to anticipate further and entertain further offers, crossing that language out is a distinction with a difference, I would argue. It's not exactly on point. They both did contemplate future offers, but it's even stronger here that the offer itself and the action in crossing that language out meant that the parties did not intend to be presently bound, but intended to be bound once they reach a mutually satisfactory future agreement. Remember also, immediately after, the next day after the offer to purchase, Murray was at the property with his broker and Meyer's broker. He was again told that higher offers would come in and the property was going to continue to be shown. He's told that, and that's on March 15th, the day after the offer. He doesn't go back and say, hang on, he crossed out mutually acceptable. I have a problem here. Can we talk about this now? He doesn't do that. On March 17th, so 3 days after the offer is signed, fully signed, he's told that higher offers have come in, but the buyers like him. And he says, sounds good. He doesn't say, hang on, I'm concerned because in the future, we may not agree. How are we going to deal with this if future higher offers come in? What are the formula? What are the procedures? How are we going to address higher offers in the future? Instead, he says, sounds good. He knows they're going to be addressed in this future purchase and sale agreement. March 18th, he sent the purchase and sale agreement with the fiduciary provisions, and he tells his attorney he doesn't want to sign them. Meyer insists on March 22nd, Meyer's counsel, that those provisions have to remain. And on March 23rd, what does he do? He signs the purchase and sale agreement with those provisions in place. They are there. And he wires $240,000 additional dollars. That's evidence that he knew it was coming, it came, and he still wants the property to go forward with that language that requires the license to sell, and that requires if further offers come in, higher offers come in, he's got to stand back, and the agreement can be null and void, and the personal representative can go forward and sell the property at those higher values. So in McCarthy, there's none of this additional context that, again, starts before the offer is even in, continues through and during the offer process, and continues immediately in the days following, that illustrates undisputed facts that Murray was aware that the property would be continued to be sold. He knew that they were going to come forward and entertain higher offers, and that a mutually acceptable future agreement is when they would be bound, but not earlier.
All right, I'm going to have to stop you there because have you finished answering the question? I think that you have. Okay, so I didn't want to interrupt you because you barely took a breath, but I think you did answer the question. So your time is up, so we're going to have to rest on your brief.
Thank you very much.
May it please the court, David Toone for Stephen Meyer, personal representative of the estate of Natalie Rubin. I'd like to address our request to have fees assessed and costs. Before I do that, I also want to supplement what Attorney Flores provided, which is that I do think when you cross out standard form agreement and put in mutually agreeable, that is a future agreement that is very different than the standard form agreement. As the court is aware, Greater Boston Real Estate Board and other real estate boards have standard form agreements. To say mutually agreeable is a very different agreement.
Well, I think their best argument may be there wasn't a material change because under McCarthy versus Tobin, similar language was treated as not opening the door to the seller imposing new terms, but they had still the sort of good faith obligation to reach something like a standard P&S, right? So I think that's their position. Do you disagree with that?
That is their position, but as Attorney Flores pointed out, the material facts at issue in this case show that there was never an assent, and as the court asked Attorney Davidson before, there was no objective manifestation of assent from Attorney Meyer. That's a critical issue here. But what I would like to do also is address the fee shifting. Mr. Murray is essentially a serial litigant, if you will. We have put materials in the record that show that it was his intent from the beginning of this to threaten massive years of litigation. He threatened an injunction and a lien on the property. He threatened lawsuits in Boston and Barnstable. He threatened $10 million in damages and penalties, that the property would be tied up in litigation for years. This is replete in the record, and Attorney Davidson doesn't even try to dispute this.
Why aren't we just looking at whether the arguments raised on appeal are frivolous? Isn't that the standard for appellate fees?
So there are two provisions at stake. Rule 25 of this court's rule is limited to frivolity, but Mass General Law Section 211A, Section 15 allows for double costs and damages associated with, to use the exact language, tactics intended for delay. And the language is frivolous, immaterial, or intended for delay.
Double costs and damages, that's not fees. That
Right.
doesn't say fees. Does it say fees?
No, it says double costs and damages. So it doesn't say fees, but I think you could interpret damages as fees, but in any event, we would request that we be allowed a further submission to set forth what those damages are. Our client, Mr. Meyer's client, the estate of Natalie Rubin, is been waiting for 2.5 years on, I think, what is a very straightforward issue. McCarthy v. Tobin these issues have been litigated for 25 years. I think this case is clear-cut. The Superior Court got it right. And so we do request, in light of Mr. Murray's conduct, which is clearly to just litigate, unless this court stops him, he won't stop himself.
Okay. Thank you very much. Thank you all very much for your arguments. We appreciate them. I will take the case under advisement, and that's our last case for the day, so the court will stand in recess.